Happy Friday night live from a very hoarse and or raspy Emily D. Baker. It has been a long week, and I can't wait to share that with you as we get on to questions. But tonight we're going to be covering kind of the bigger moments in the Johnny Depp Amber Heard case with some legal things that happened. If you've been watching along with the testimony, it's been covered by a lot of the law tubers here on YouTube. I had multiple live events that I was speaking at this week and a date with a karaoke bar. So I was not streaming it, but I'm going to cover some of the legally significant points in the Johnny Depp Amber Heard trial. We're going to talk about what's going on with Rob Kardashian and all of his sisters and Blac Chyna and that trial that is kicking off today. And we are going to talk about some new filings from reality star Todd Chrisley against a YouTuber who he calls nondescript. So we're going to be doing all of that today. Replay crew, love you. Everything will be timestamped. I will be doing questions kind of towards the end, and I'll give a roundup of what went down this weekend at the end of our stream. It was so good to see so many of you in person here in Nashville, including our own mod, Katya Cotton. It was so good. I have pictures that I need to send you. I forgot to do that. I am so tired. I am so hoarse. I am so tired. So with all of that, we are going to cover those things. I am going to stay hydrated and mind all of my business. This is how we're rolling. This is how we're rolling. This is how we are rolling. For those of you, well, actually, let me cover that during kind of our welcome. Let me know where you guys are coming in from and what you're drinking, and I will tell you a little bit about what's happening. And with like my channel and a little company called Law and Crime. Let's talk about that after we come back from the intro. We're going to roll it and we're going to get right into this. We've got a lot to talk about tonight, and we don't know how long this will last. Zach, Peter, and I were karaokeing. I think I sang 7 songs at karaoke. It seemed like a good idea at the time. And then at the end of the night, I'm like, ouch. What am I doing? But it was a really good time. So, don't threaten me with a good time. I love me some karaoke with friends. So with that, we are going to get started. Timestamps will be down below. Mods, it's good to see you. Law Nerds, it's good to see you. I feel like this is the first and last place I've been. Like Tuesday, I sat down, I streamed, we talked, all hell broke loose. I threw stuff in a bag, scooted up to downtown Nashville, and was, from the time I left my house, was literally nonstop except to sleep, and then rolled back in to my home after dropping Octo at the airport. But he left a little piece of him with me. So we've got a new little friend. We'll have to name our octopus. If he gets to stay in my office, Griffin is trying to steal him. And Octo was like, we need representation. I'm like, we have octopus representation. So he is here. But Griffin was already like, is that mine? And I was like, with all things. So let us get going and talk about the things. Let me know where you're coming in from, what you're drinking. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see so many of you coming in. A lot of us are drinking water this evening, but for some of you, it's not evening, and I understand that too. So in a quick little roundup, before we started, Tech was like, are we doing a roundup? And I was like, no. And then I'm also like, but maybe just a little bit. I wanted to point one thing out that I just saw as I was logging in to talk about all the things. So I'm going to share it with you real quick. But let me pull it up for sure. Where in the world is what? Emily, are you prepared? This much. No, we're totally prepared. It's just a whole thing. So Peter Mon put out a new update on his community tab with an update on how he's doing. So instead of giving you my words, I'm just going to give you his words and share what he shared with his community. Is your share screen ready? No, it's not, but we will be. So I've tried to switch browsers so that my browser doesn't crash like it did last time. So with this, we have a quick update from Peter Mon saying, hey guys, I know it's been a really long time, but I wanted to stop in and give you an update, especially since there's been a lot of questions. Due to the seriousness of the accident, I want to be sensitive to everyone involved and won't be addressing it in a post, but I will talk about it in my first video back. I just don't think it's fair or does the severity any justice to talk about it in a written statement. First of all, I want to thank everyone for the outpouring of love, compassion, and kindness. There have been so many people who have checked in with me daily, many I've never met, and I want everyone to know truly how grateful I am for the love. I know many people are wondering how I'm doing, so here we go. I am walking again, but have some pain in my back, and the doctors tell me I probably will always have some sort of pain from now on. That said, I'm able to leave the house and function. I am attending a neurological clinic for my back, and they have released me from having to wear my brace daily. My mouth injuries have healed, and my ribs are almost back to normal. I am working closely with my neurologist with testing and checkups regularly. 2 weeks ago, I found out the results of a CAT scan that I have fluid and bleeding on my brain as a result of the trauma. I have another CAT scan on Monday, and I will find out more about what we do next based on the results. I've been extensively working with a new therapist twice a week for the mental and emotional reaction to the accident. Well, it was a very, very severe accident. I can only imagine. I've missed you all greatly and hope to be back sometime in the next month, but that will be determined by the results of the CAT scan and what I have to do next. My therapist is encouraging me to come back to YouTube, and although I know things will be different, I'm hoping to find my way back. One last thing, I wanted you guys to know that we lost little Tucker last week. Oh, what a very, very tough time for Peter Mon. He suffered internal bleeding they believe was related to an aggressive tumor, and his little body couldn't take it. The house is emptier without him, but we are giving his brother Boo all the love in the world. Once again, thank you guys for the love. It's amazing to me that there's so much kindness in this world from people we may never meet. I love you guys. And from Peter. And I can absolutely, absolutely say that Peter's community, like the Law Nerd community, is so tremendously incredible with the love, with the support from people that we've connected with through the internet, but not in person. That support is it's almost overwhelming, and there's almost not words for it sometimes when you talk about how supported creators can feel. And it's always so confusing to me when I hear creators talk about their audience in a way where they are either at odds with their community or at odds with those who watch them, and there's this like almost push-pull fight, because the creators that I have grown to be friendly with and who I love to watch have a very supportive relationship with their communities. And it's what I love about the Law Nerds. I realize that that takes cultivating, but y'all are part of that cultivating. And Peter has done that with his good Judies as well. So even though it was a very severe accident and he has had lots of injuries, I'm glad to see him sharing what he's doing to heal, what he's doing to come back, and what is going on with him in a way that felt comfortable to him. And I was really happy to see that as I logged on to the internet this evening. I have not been online much, and it's something that I don't have a good gauge for, and I don't know if I ever will. When I'm in real life doing things, there are times I absolutely forget to pop back out and pop on to the internet. I absolutely get very engaged with where I'm at. So if I'm online with you guys, I'm online with you guys. Nothing else exists. If I'm like in the real world doing real world shit with the people, then I'm very much doing that. And it's like, oh, I should post and tell people what I'm up to. So I very much get focused with where I'm at. Octo, we were just sharing that you are now represented in the office. And for those of you that follow me on Instagram, you got to see a lot of Octo on my stories because he was out here in Nashville with me. And I heard from a lot of you. Look, I'm going to remind you again, Law Nerds. I'm going to remind you again. Married. Octo's married. A lot of you made some very kind offers in my DMs, but still married. So with that, we are going to move on. But I was really just heartened to see it. Love seeing a message from Peter. Always wish him the best. Have been blessed to get to communicate with him offline as a friend, and I'm glad he's sharing what's going on. So, with that, Rachel, you are welcome. YouTube has been crazy lately, and I saw the notification and wanted to show you guys. Kissy Kissy, I'm gonna let you go to Instagram and find that out for yourself. So, with all of that, I said I was going to do something else next, and I've already forgotten because I've gotten distracted. Because I'm so sad for Peter's loss of his dog. Because I can't imagine how, when you are healing, that is when my pets have been so instrumental in my healing from back surgeries and spinal fusions and all the things. So losing a pet in the midst of that would be absolutely devastating. So I will go and send love to Peter. In the world of the onlines and the world of the offlines soon. There was another update I wanted to give you guys. Oh, Kardashians. We're doing Kardashians next. I think that's what we're doing next. Let's do that next. Are you ready? Are you ready to do Kardashians next? Let's do Kardashians next real quick. A short update for this. And I think I was also just expressing all of my love to the Law Nerds because, again, being in Nashville in person with y'all, it was so just heartwarming to get to see everybody and hug everybody and jump up and down and giggle and have a drink and be in person with the Law. I just love it. I love it. I love y'all. So I'm kind of overwhelmed with not just being tired and losing my voice from singing everything from WAP to Take Me Home Country Road, but from getting to chat with so many of you. So let's talk about the Kardashian trial real quick. Rob Kardashian and his sisters are all in trial with Blac Chyna, professionally known as Blac Chyna, Angela White. She sued Rob Kardashian. Rob Kardashian countersued her. There were 3 cases combined into one. I have been needing to do a roundup of it. Today was the first day for trial. I'm going to share the minute order from the court from what happened today, so we can keep an eye on what's going to be going on with this trial, because this trial for real is happening. This is happening. It's going to be starting shortly, probably on Monday with jury selection. But here's what's going on. Let's make this a little bit bigger. This is the minute order from today, April 15th, for plaintiffs. This is plaintiff's attorney. This is the attorney for all of the defendants, which is Rob Kardashian, Kylie Jenner, Kris Jenner, Kim Kardashian. There's another one. So, Christina, I'm going to tag this. We're going to be covering this. So, yes, thank you. We're going to cover that. So, matters called for hearing this morning. Court and counsel confer regarding jury instructions, verdict forms, ex parte issues, and the motions in limine. Counsel are ordered to return at 1:30. Court and counsel defer regarding deposition transcripts, confidential documents, and jury selection. Counsel are ordered to return on Monday at 8:30. So 4/18, I'm assuming is Monday. I hope that's Monday, right? Emily, it feels like it should be Monday. So with it feeling like it should be Monday, that looks like when they will be getting to trying this case. So going over deposition transcripts means they're going to edit any final things. Motions in limine mean they're finishing up what's going to be admitted and not admitted into trial. Jury instructions are going to be the opening and closing instructions, and the confidential documents, how they're going to enter those in on the record, note them, keep them confidential if need be, etc. So Monday we should be getting the transcripts. So, or not the transcripts. We should be getting the beginning of the trial and jury selection. If they've got more motions, jury selection could start Tuesday. It's not super clear from this minute order, but we will see this starting on, Monday, Tuesday with jury selection. So we have to rely on reporters in the courtroom. All of the motions for recording in the courtroom have been denied. And it might be because some of the topics in this trial are sensitive. It might be because the judge doesn't want it. It might be because the parties don't want it. It might be because they don't want this case to become a circus, as can happen when there are cameras in the courtroom. And we're going to talk about some of the things that can go wrong with cameras in the courtroom in the Depp Heard case in a few minutes. But with this, we're going to have to rely on reporters in the courtroom if there are any reporters in the courtroom, but it will be open to the public in Department 96 at the Stanley Moss Courthouse, the courthouse where Brittany was. Kate's asking, isn't Easter a public holiday? No, Easter is not a public holiday. So today is, I believe, the beginning of Passover. Today's Good Friday. A lot of companies are closed on Good Friday, but it is a company by company basis. But no, Easter is not a public holiday, and there is no Easter Monday as a day off. So with that, we are going to Just Hearts NYC. I'm so over the Kardashians. Fair, but with this case, there are some very interesting questions. So I am going to cover the questions of law in this trial that I find really interesting. There are questions of revenge, PORN in this case, and there are questions of interference with contracts. Did the Kardashian family interfere with the Rob and Chyna show going forward? And if they did the contract get bought out? Did she lose money? Those are very real things where you can get a very solid case to a civil jury. Like she's alleging they blocked her show from going forward into season 2, even though it was already picked up for season 2 of Rob and Chyna. And if that's proven and there are damages there, she could win on that if she proves that they blocked her show and didn't allow it to go forward with filming, which will be a very interesting thing to see. So there are questions of law that I am very interested to see how they play out in a civil case like this. But Rob Kardashian's also countersuing, and that will be a very interesting thing. How they rope everybody in. There are a lot of interesting legal questions for me, and I'm going to do a breakdown of it. We just haven't gotten to the legal breakdown of it yet because it is 3 cases that are now being combined into one. But we also have so much going on with the Depp Heard trial, and that is going to be going on and on and on. It is estimated to be a 6-week trial, and we've already seen it be a little bit explosive, which is interesting. And we definitely have some things to talk about with that. So that is a heads up on what's going on with the Kardashian et al. Trial. I am very interested in it because there are a few legal questions that I very much want to see play out. So we will be covering it. We are not going to be covering it in nearly the depth that we're covering everything else. R. Briscoe asks, is Kim K a legit attorney now? No, she is still a law student. So she is still a law student. All right, let's go over some of what's happening with the Depp Heard case before we get into the new Chrisley filings and then Q&A. I'm going to do my best to not completely lose my voice before the end of today's show, but we've got a lot of documents to go over for sure. So let's talk Johnny Depp and Amber Heard real quick. The Johnny Depp Amber Heard case kicked off this week in Virginia. Again, we talked about it being in Virginia because the heart of this defamation case is Depp's lawsuit against Amber Heard regarding an op-ed that she wrote in 2018 in the Washington Post that has servers and printers in Virginia. There was lots of fights over jurisdiction. This was not easily decided. This was a hard-fought decision. Part of that, I still think, is strategically the anti-SLAPP laws are different in Virginia. And I think that's a big reason why it's there. Though in opening statements, we did see Heard's attorneys wandering some about this being another form of Depp's harassment against Heard by dragging her across the country to sue her in Virginia. More of a way to harass her than the legitimate, proper legal form for this case. I covered the opening statements. Well, I covered Heard's opening statements live because I covered them during our regular Coffee and Cursey Words time, and Depp's attorneys had already completed by that time. I streamed it live, and then my channel received a copyright strike from Law and Crime Network. The level of annoyance was real, and I started a second stream to cover not just my annoyance, but kind of my thoughts about the opening statements. After I did that, I had to peace out for two live events that I was doing, one at a entrepreneurial conference and one Spilling Tea Live with Zach and Adam. So I did not have a chance to do much other than acknowledge that it had happened and go and handle the other work that I had. Funny enough, or maybe not funny enough, I tweeted about it. A lot of you tweeted about it. Nick Ricada and others tweeted about it. And Law and Crime removed the copy strike and released the video. So it is now back up on my channel if you would like to see my live reaction to the opening statements of Amber Heard's attorneys. I liked the first attorney very much more than I liked the second attorney who quite wandered. But you can see my live reactions to that. My biggest takeaway from opening statements were really their theories of the case. Then we get into witness testimony for the last couple of days. Legal Bites has been rounding them up on her channel. She has been streaming the case live every day with commentary and then doing kind of a roundup at the end of the day. But since I was at live events, I was not doing that this week. I will be doing it more in the coming weeks because we absolutely have to. Well, we don't have to. I absolutely want to see some of the other witness testimony, and we're going to start getting into some key witness testimony, it looks like, on Monday with Elon Musk. So I am ready to see the things. I think in the opening statements, they did allude to the fact that Amber Heard dated Elon Musk, which had been largely denied. And I was so curious about why the attorney said that. We had a key witness, or who might have been a key witness for Johnny Depp during this case, a friend of theirs, Georgiana Deuters, 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 something like that. Georgiana, I watched her testimony until she got yeeted, and we're going to talk about her getting yeeted real quick. So I watched her testimony. She is somebody who became couple friends with Johnny Depp and Amber Heard, but had been friends with Johnny Depp even in his previous relationship. Talked about the fact that she actually had not seen him use drugs all as much as maybe is being alluded to by Amber Heard's team, and that she hadn't seen him be abusive. Was really of course, a friendly witness to Johnny Depp. And of course, she's a friendly witness to Johnny Depp. We're in his witnesses. This is his part of the case. Most of the witnesses are going to be fairly friendly, though we did see their marital therapist testify that this was a combative relationship. And I can talk a little bit about why we saw their therapist testifying via prior deposition. When you see those prior deposition videos, and those are deposition videos that were done well in advance, where both lawyers have an opportunity to depose people, much different than a criminal trial. So everyone knows what's coming in these depositions. Like they know what these depositions are going to show. Both sides have had a chance to make objections to them, edit things out of the depositions. So these are what's left of these depositions. So, and what I mean what's left is what hasn't been objected to or taken out as speculative and what have you. So this has been agreed to. It's obviously been agreed to that this therapist can testify and be deposed because the parties have the right to waive that privilege. And we got a lot of motions in this case about HIPAA and HIPAA releases and things like that. So the therapist was allowed to testify because of that. But this was done at a deposition, again, a number of years back. So as I wandered from the point of Georgiana Deuters, she was a friendly witness to Johnny Depp and starting to testify about Johnny Depp. And in the middle of her testimony, she was asked if she had been watching the trial. Now, I thought, presented really well as a witness. She came across as very credible to me. She came across as someone who actually did know them. She clearly wasn't very, you know, f- bothered by narcotic use. She talked about it in a very casual way. She talked about the fact that Johnny Depp kind of disengaged when he and Amber Heard would fight, et cetera, et cetera. Then it came up from Amber Heard's team that they wanted the judge to ask if she had been watching any of the trial. There is speculation that she had liked a post on Instagram or something like that with clips of the trial, and some of that is broken down in Legal Bites Roundup because Legal Bites stream was featured in an Instagram post that was then discussed in all of this coming up. So with that, you now have a witness in a trial who says that she had seen clips of the trial. And she, again, was a good witness for Depp. She said that she had not seen him be aggressive, that she didn't see him, she had seen him do drugs, but she didn't see him be really bothered or significantly altered by them, et cetera, et cetera. So, with all of that said, to have her testimony struck, I think could be damaging, especially because civil attorneys are crafting the story that they're going to tell, and they are step blocking together this trial. So it's, one step, one step, one step. It all builds on each other to get to the story. So this was a step that they had planned on. This witness is going to tell us these things, and is this part of the story, the wedding, the stuff in Australia, that kind of stuff. And then in the middle of her testimony, the motion is brought by Heard's team to the court that there was concern that she had watched part of the trial. With that, the judge asked her or inquired outside of the presence of the jury if she had seen anything about the trial on social or if she had seen any of the trial. And she said, yes, I've seen clips of the trial on social media. Yeah, that's a giant no-go. What you can't do as a witness is see anything about the trial. The witnesses are sequestered away from the trial until they are dismissed as witnesses. Witnesses can't be in the courtroom, and there's a reason they can't be in the courtroom. Witnesses to a case have to have independent testimony, and their testimony could be tainted or swayed by other witnesses. So you can't sit in court and watch unless you are an expert witness or certain officers, investigating officers, the officers that took testimony, things like that, can stay in the courtroom because, again, they are more like expert witnesses and they already heard all the witnesses because they did the interviews. So in criminal cases, you will see some police officers allowed to stay in, the investigating officers. But you won't have the witnesses in the courtroom to hear what all the other witnesses say. And when you have something that is broadly televised, and on social media, the witnesses should have been advised by Depp's legal team more than once that they needed to go to lengths to avoid any reports about the trial, any clips on social media, clips on TikTok, stories about it, news coverage of it. And it is on them to avoid any input about the trial until they are done testifying, which with a case like this can be very difficult for a witness to do. Now, if they weren't liking posts, I have no idea how they would have known. But if she was actively engaging on social media, there's going to be an assumption that she could have seen something, and they are going to have to ask about it. To her credit, she answered honestly and said that yes, she had seen clips about the trial. They can't see opening statements. They can't see anything about the trial. So she answered honestly under oath, but was immediately dismissed as a witness, and all of her testimony was struck. So with all of her testimony being struck, the jury will be instructed that they can't consider her testimony. But with her not being able to consider her testimony, it's very difficult because the bell's already been rung. The shit's already out of the horse. She's already said what she said, and the jury's left with an impression of their mind. Like, it's not Men in Black. You don't get the little like wandy thing and like erase your memory. So it's very hard in trials because parties can be prejudiced by that testimony. The thing is, this is a 6-week trial. There will be lots of other witnesses. I don't know if her testifying is going to be something that is so appealable that it's a huge issue, but it could be down the road. The judge did the absolute right thing in stopping testimony once it was brought up, stopping testimony, excusing the jury, inquiring as of the witness. And when the witness said, yes, I have seen clips, the judge was like, that's all I need to know. You're out. You're done. She said clips of the trial, and the judge is like, clips of witnesses and things. And she's like, I've seen clips of the trial. And that's it. So with that, it's interesting in a case with this much money behind it, with the fleets of lawyers and a large or a witness who was important to the case, that this wouldn't have been more locked down. I wonder which lawyer was in charge of this witness, I'm sure, or which witness coordinator was in charge of this witness. I'm sure there will be lots of conversations with Depp's law firm about how Depp and his law firm about how this was allowed to happen. It's just kind of wild. I've not seen anything quite like that. But you also can't control what people do on their phones. And it's very hard. We've seen this in other cases where there's been conversation about something happening and jurors seeing news alerts that pop up on their phone, even if they're not searching for the information. And jurors who've said, oh, we knew the court dismissed these charges while we were deliberating because the news alerts popped up. And that is, that's something that courts are going to have to contend with going forward and are going to really have to consider going forward. But anytime you are involved in a trial, know that everyone's especially a trial like this, everyone's watching what you do, and there's no way around it. So it's an issue in cases that are televised. And it's going to continue to be an issue in cases that are televised. But let's talk about Eve Barlow being barred from this trial, because it seems that Eve Barlow is the one who brought this to Heard's team's attention. And I say seems because that is other people's impression on the internet that is being reported, but I don't have personal knowledge of that myself. And I have not seen that be directly stated by Eve Barlow. I've seen it discussed and speculated about, and it seems that way from the videos from the courtroom. So let's talk about that for a moment. There is a minute order from today barring Eve Barlow from the courtroom until the end of the trial. So the plaintiffs brought a motion. I'm sure they did. And I'm sure part of this motion was responsive. And the motion is filed under seal because it's not publicly available. Upon consideration of plaintiff's motion to exclude Eve Barlow from the courtroom for pendency of trial, that's the remainder of the trial, any opposition and being fully informed, it is this 15th day of April. So hereby ordered as follows. Plaintiff's motion is granted. So Eve Barlow is barred from the courtroom for the rest of the trial. I don't know if that will also include the overflow courtroom. I imagine that it will be. They didn't say courthouse, which is interesting, though this is televised. So this individual can sit on a laptop outside of court and see what's going on, or sit in a hotel room near court and see what's going on. But it is widely speculated that she is the individual who saw the things on social media, brought it to Heard's attention. She is a friend. Who's Eve Barlow? I'm sorry, I did not back up as I just launch into things. My brain is very tired. Eve Barlow is a friend, and I know the chat will probably have much more information, but seems to be a friend of Amber Heard, has shown up with her every day for trial, has been active on social, indicates on social media that she is a independent journalist, and that. So she has She's been coming to court with Amber Heard day in and day out and sitting with Amber Heard's legal team, or sitting in the front row with Amber Heard's legal team. Reporters on Court TV indicated that they also saw issues with Eve Barlow being on her cell phone. So this was reported by Court TV. I saw it today that Eve Barlow was on her phone in court, and you cannot be on your phone unless you are one of the attorneys. You can't be on electronic devices at all unless you are an attorney in the courtroom. So she was on her phone. The reporter from Court TV, or the yeah, right, we're going with reporter, the individual from Court TV said that she saw Eve Barlow on her phone, then saw sheriff's deputies remove her from the courtroom, and then she came back to the courtroom, and then she was on her phone again, and then this order happened. So with all of that, she has been permanently yeeted, and with that, she will no longer be in court. It's very interesting. Christine's asking how this will impact the trial. I don't think it really impacts the trial much. It might impact the fact that she's not able to support Amber Heard and in the in-person kind of a way, but it seems like she was trying to work with the legal team. I don't know what the legal team wants with that or doesn't want with that, but yeah, so that's what's going on with that. So I'm going to see some of your other questions as we're going through this. And just a reminder, and I forgot to say it at the beginning, when we talk about the Johnny Depp Amber Heard case, I know it's a contentious case with parties that not everybody likes, but we are still law nerds and we don't name call. We still have chat rules. So that's what it is. So Amber Heard, I imagine, is allowed to be on her device. She's one of the parties. I've seen her on her phone just watching the trial as well, like making notes to her attorneys. And I imagine she would be allowed to be on a laptop because she's one of the parties. So I don't know if the court hasn't said she can't, but the journalist in the audience and the rest of the audience can't be on their phones, and they don't need to be on their phones. It's all being recorded. So with that, so that's why Eve was thrown out. The second time she was using her Apple Watch. See, I saw Court TV say that she was on her phone twice. I don't know if she came back in on an Apple Watch. I mean, it's definitely possible. Question: how did Eve get these spectators' names to get ejected? I don't know. I don't know if she got spectators' names. I don't know anything about that. So Legal Bites seemed to think Eve was like part of the team. She was sitting with them during trial, so I can understand that. She was sitting in the front row that was reserved for really the team and like the people working with the team. There were also people moved back in court, and you saw like people that were in the front move back. I don't know what all that was about. I don't know if we will know what that was about, but you can't be on your tablets. So with that, Yay Hill, I'm not going to say one way or the other. Is it bad to say you hope Depp wins? No, I think a lot of people do hope Depp wins. I think people have strong opinions coming into this case. I just ask everyone to keep an open mind and cross the information with what you've heard. Not everything that's going to come out about Johnny Depp in this trial is going to be favorable to him. Not everything that comes out about Amber Heard is going to be favorable to her. It's going to be, I think, mutually assured destruction in all of this. I think it's going to be very damaging to both of them. And I think we saw that with their marital counselor saying that both of them have essentially a toxic relationship. That's not the word she used, but both of them have engaged in kind of abusive behaviors. Now, because it was a deposition, you don't have the lawyers able to follow up there in court saying, define abusive, verbally abusive, emotionally abusive, physically abusive, and talk about it. But they did talk about Amber Heard initiating fights and things like that. So this trial is going to come down to who the jury believes. It's going to be very sad. And we've seen the beginning of that with both legal sides saying these are people who grew up in abusive situations and trying to figure out who my sentence totally ran away with me, but you see both sides talking about the childhoods of these individuals, and then it's going to be which one's more toxic and who's initiating who, and it's going to be really hard for a jury to decide. And at the end of the day, they might say, you know what, this is mutual, both of you did it, and we're done. So it's going to be very interesting. Juliet said, did they open the court to the public because both parties think it will have an advantage? Juliet, courts in the US are always open to the public physically. So you can walk into a courthouse. I mean, after you get through the line and the metal detectors, and if there's a really high profile case, a wristbanding situation and stuff like that, but you can always get to you can always get into court. Court is open. Juvenile court is not. There are very few other types of cases that sometimes parts of them are sealed to the public, but courts in the US are open to the public. You can walk into a courthouse and go watch what's going on. Just walk in the back doors. The reason I think this is being televised is because A, there's a lot of interest in it. And B, I do think both sides think it will help them. It's like, well, once the public sees everything X has done or Y has done or whatever, maybe they'll understand my side better. I think this was the only option. I think on this path of mutually assured destruction on a case that never should be at a jury anyway, I think that the only option is for all of the dirty laundry to be aired out in public for these two. I don't think necessarily that's the right option, but that's the option they're going with. So everything's going to be aired out and the public will get to see all of it, and the public will come to their own decisions, and the public and the jury might not agree, but they're going to see all of it. So, Andrew O'Reilly said it's so sad to watch. It is sad to watch. It is sad to watch. I mean, it's a lot. It's really a lot. And it really is the inside of a toxic relationship playing out in real time, which for everyone who's been in relationships that are abusive mentally or physically or emotionally or manipulative, I imagine this is also very hard to watch it all play out. So I see NJ in the chat, who's probably also home resting her voice. Hello, friend. All right. So I didn't get to watch all of Isaac's testimony. The testimony I did watch of Isaac, I really did enjoy. He came across as very credible and likable to me. So I really did enjoy it. Could this be considered the equivalent to each other and the jury? Could this be considered? I'm not quite sure what you mean. And again, I pull up questions before I read them all the way. So I'm not sure exactly what that refers to, but ask it again and I'll try to star it. Question: if Amber does win, can she press criminal charges, and would her civil win benefit her criminal case? The statute of limitations on the criminal is long gone. She could have pressed criminal charges. If the police came out and made a report, she could have pursued it. At the time, she got a restraining order and it was not pursued at that time. It is too late to pursue that now. So it is too late to pursue that now. Depp expressed embarrassment for allowing Amber to obtain me. Wild way to think about a marriage. Yeah, it is a wild way to think about a marriage. It's a very strange case to watch play out. And I'm going to absolutely be looking at how the attorneys are doing and what they're doing. I'm looking at how Johnny Depp and Amber Heard are dressing for court, how they're interacting or not interacting in the courtroom with the jury, or looking at them or not looking at them, if they're looking bored, if they're looking sleepy. It's a hard thing sitting through watching your friends and people you've worked with and people you like or people you hate be questioned and cross-examined is a tremendously difficult thing to sit through. And it's going to be very, very draining for both of them. And maybe we'll get back to the fecal phobia and we all can have another WTF moment in this trial. But it is going to be very interesting as it goes for 6 weeks. So that I'm going to move on to our other stuff and then get back to questions. I know you guys have a lot of questions. I'm trying to star some of them as we go through so I can get back to them when we get into the rest of the questions. Let's see. There was one I just saw that I wanted to answer and I just where did it go? I don't know where it went. Somebody was asking about the audio. Delaney. Do you think they'll bring in the recorded convo where Amber Heard says, "I worked so hard to make our wedding happen"? Probably. I can't imagine that recording wouldn't come in unless they were able to keep it out for evidentiary reasons, but I don't think that they will. A lot a lot is going to come in. Um, Lala Green Eyes, it sure seems like Amber Heard is copying Johnny Depp's court outfits. It's very odd how much similarity there's been. And I like why? And like, how are you ready for that? Like, how does she know what he's going to wear to actually have that on hand? I have so many questions about it. It's so strange to me, the similarities that we've seen in their court actions. Delaney, now you're on screen twice. The court fashion has been very odd to me. It's been very odd to me. Yeah, I know. Cindy Thomas, she wore a similar tie. I know. It's so odd to me. And like, how are you ready? But I own like 7 things. So it's very odd. You guys look it up on the internet and see what you think for yourself. I'm not going to, yes, I am. I'm not going to pull it up. Also, me, we're doing it now. Things are happening. We're making decisions in real time. And then we're going to move on to a bunch of new filings. Oh, there we go. Amber Franco said he wore the tie during the UK trial. Amber, this is good information. I didn't pay a ton of attention to the fashion in the UK trial. So interesting. And that's how we know. But it has absolutely been an interesting thing to watch the fashion in this trial. Let me see if I can pull up a side by side of the outfits. Let's see if I can adequately form a Google search to bring up exactly what I'm looking for. I think there's a Reddit. Of course, there's a Reddit. Let's see. Viewers point out, here's one of the things, is the B tie. And this is coming from, I have no idea. This is the first one I saw on Google. So the B tie detail coming into court day after day. Let's see. The only winners at the Johnny Depp Amber Heard trial are Gucci and Dior. Oh, well, I guess that's where the ties are coming from. I don't want to go back to Twitter. Nope. Let's see what else. So again, lots of Depp's tie day 1, Heard's tie day 3. True, it's not body language, but I find it super creepy. This is the tweet I had originally saw too, because it definitely went a bit viral. But yeah, it's a very, very odd coincidence. And this is Isaac, who we were talking about. I very much liked Isaac. I didn't see the entire testimony again, but I very much liked Isaac. So he wore a vest the other day that was snazzy. I like the vests on him. So with that, I will be keeping an eye out for it to see what else happens. But we have some very public filings that we need to go over with a warning. So, and then we'll talk. If you guys want to talk more about court fashion and my thoughts on court fashion, we'll do it during Q&A. I'm totally happy to talk court fashion. It matters. Like, what the attorneys wear and look like matters to a jury. We are people. We judge other people, and you judge witnesses, and they judge people on site, even if some of it is subconscious. So it does absolutely matter. There is a lot being planned out here, and I imagine Heard not only has a makeup artist and a hairstylist, but also a stylist for court to figure out what they're doing. So, chat, with that, I'm going to swoop to our next topic at 48 minutes in. We have a lot to talk about. So let us give some disclaimers, because every time we talk about these cases, disclaimers are needed. So we are going to talk about some new filings in the Todd Chrisley case. He is suing a YouTuber here on the platform who, as you all know, hates me, which is fine. I really don't give a shit. This particular YouTuber is not someone I enjoy covering. I don't have particularly strong feelings towards them one way or the other than I generally wish they would just stop talking about me, my channel, and stop getting shit wrong when they talk about me and my channel. Other than that, really generally don't care. So with that, I always ask the chat to just remember that with this particular YouTuber, And with all of the controversial people that we cover, we do not disparage, besmirch, talk ill of, wish ill upon, diagnose, all of those things. But there are so many defamation cases going on with this one particular YouTuber that we need to talk about them. Also, Todd Chrisley is a public figure who I am very interested in covering their case. He also keeps talking. When I say don't talk about your case, he also is talking about his case. He's not going to stop. I've gotten that. I've heard that loud and clear on his podcast. He has talked about this case on his podcast a bit. It's always interest again. I'm here for it. I always say, don't talk. Don't talk about your cases. But if people are going to do it, I'm going to listen to what they have to say about their cases. We are finding out about cases in real time because of social media. And it is a brave new world where what you do on social media not only can end up being filed in the next filing in a case, can end up bringing more cases, but can also end up impacting the way people view not just a creator or a personality, but also the case. Like the court of public opinion game is strong and it's strange. And we are going to talk about it. So let us we're going to lipstick. We're going to lipstick and then we're going to talk about it. So Todd Chrisley from Chrisley Knows Best has sued. Let me pull up my notes because I forgot when this particular lawsuit started. It's been a while. It's been a while since we've checked in with the Chrisley lawsuit. We've had other things to cover, and it seems like it's been in discovery, so it's been in kind of a hiatus. But I'm just going to pull up the docket real quick to give you the date that this was filed. This is a defamation case filed by Todd Chrisley against YouTuber here on the platform, KJ. I had the docket up, and then it disappeared. Why? Probably because I clicked off of it. No, I timed out. All right. So this original complaint was filed on November 8th, 2021. No, that's the motion to dismiss. Where is the original filing? No. Is it November 2021? No. Yes. November 8th, 2021. So this was filed as a complaint in November 2021. A motion to dismiss was filed. This is a defamation case covering a number of statements regarding Todd Chrisley and his family. If you want to look at that, it's on the channel. You can go take a look at that. We're just going to take a peek at what's been going on in this case since then. There is a motion hearing set for April 27th at 2 p.m., but there are some motions in here to move some of those hearings. There's also a motion hearing set for July 20th, 2022 at 1:30. So with that, I'll just pull up the docket. We've got the motions, the case filing, the remote hearing, a notice of deficiency in November, notice of service. The discovery plan started in February or December, which means the discovery started then or should have started then. Hearings that I believe this hearing got moved to that hearing and that was a discovery matter, but I don't remember off the top of my head. And then really nothing until now. And we've got new motions and we're going to go through those new motions right now. So because we cover court cases, we've got a court case with some new motions and we are going to cover it. I just want to make sure I pull these up in the right order because your girl is tired. Very, very tired. So this is a discovery motion. Let's just pull up. I'm going to pull up all of these. Am I going to reverse myself? Yep. That's a correspondence. Where's the motion? Because I want to do the motion first. All right. That's a memorandum. That is the notice of motion. And motion, we're going to start with that and then we'll go from there. So some of this may be a little bit out of order. That just I'm tired. So let's get into plaintiff's notice of motion and motion to compel discovery. Just a quick note on discovery. Discovery is the process of the sides asking each other interrogatories, which are questions to be answered under oath, asking for documents, asking for production. And discovery is a critical and crucial part of a civil trial. Criminal trials are not the same in that way, because the rules of discovery in a criminal trial are basically, hey, prosecutor, do you have it? Great, give it to the defense. It's very easy. There's not a lot of finely crafted things going on unless you're redacting out personal information for safety. The discovery is mostly like, I have this, here you go. It's not wild, and the defense doesn't have as much of an obligation to turn over things to the prosecution, unless they're going to use it for impeachment, and then it does come in. Like the whole thing with criminal discovery is much different. Civil discovery can become a game of hide the ball. I still want to know what the judge has ruled with regard to the pictures in the Amber Heard Johnny Depp case, because she has been playing, fuckery with digital evidence, and we still don't have an answer that's filed in court. Hopefully, when those get introduced, the court will make a mention of what they decided to do with that digital evidence. So civil discovery is a much lengthier process that includes depositions, interrogatories, which again are questions that you respond to under oath, and requests for document production, like, give me this, give me that. And then you can object to those things. So you can ask a side for discovery, and they can object and say, you don't get this for this reason, or you don't get this for that reason. And then the court has to say, everyone, you give this to you and you give that to you. And that's what we saw so much of in the Depp Heard case. A lot of the motions and things we talked about in the motions for sanctions were, Your Honor, you ordered discovery and I still don't have it yet. So we're at the beginning of that process here with Todd Chrisley in this lawsuit. So let's look at this notice of motion and motion to compel discovery to the defendants and their attorney of record, Graham Martin. Notice of motion. This will motion to compel discovery on July 20th. So this will be a discovery hearing that's happening then. Motion. Let me see there. Salamia said, this case does seem to be taking a really long time. No, this is the normal pacing. The Toddy Westbrook case and a few others picked up at an unprecedented pace of litigation. It came in hard and fast in those cases. It was just, this is a much more normal pace. Civil litigation is normally fairly slow, and this is a much more reasonable pace than some of the other things that popped off so quickly that we were just like, oh, what is happening? Like those cases popped off very, very fast. So with that, let's get into this. All right. I see you guys saying hi to viewer's voice, but I didn't see him say hi. But Nick, if you're in the chat, hello. We're just getting into Lawsuit City over here. All right. Plaintiff's motion is made pursuant to the Minnesota Rules of Civil Procedure. The basis for the motion is that defendants, and defendants in this case again, are KJ and Without a Crystal Ball, the company side of it. The basis for the motion is that defendants have rendered an incomplete response to plaintiff's interrogatory and failed to timely produce relevant and responsive documents. Plaintiff has cause to move the court for an order compelling defendants, which is the court saying, give it now or not. It just depends on the court. And again, this is a normal part of the, discovery process. So that's our notice of motion. Let's see, where's our actual motion? That's the request for continuance. We've got notice of motion. Now we want the motion. Which has to be attached here somewhere. Sorry, y'all. That's notice of motion in motion. There's got to be more. I'm not seeing it. Oh, this one. Sorry, y'all. It's the correspondence. Here we go. This is filed the same day as the notice of motion and motion to compel discovery. To the judge, letter filing. That's why it's in this different format. To the judge, plaintiff Todd Chrisley writes pursuant to the rules of court to seek an expedited informal conference relating to two discovery disputes with KJ. and a refusal to respond to an interrogatory that is at the heart of the plaintiff's claim, as well as their refusal to produce documents in a timely manner. And again, these are all watermarked from the court. I love that Minnesota does this. It makes it very clear where the documents come from and if they come from the court or not. So this very clearly, Minnesota Judicial Court comes from the court. Under the parties' joint discovery plan, which has not yet been approved by the court or formalized into a scheduling order, the parties are to complete fact discovery by July 29, 2022, which means they are coming. I mean, we're in April. In litigation terms, July is coming. She'll be coming around the corner as she comes. Like, she'll be coming around the corner as she comes. July is coming. You've still got to get deposition plans. You generally can't get depositions fully planned until you have the interrogatories complete, because you want the information from the interrogatories so that you can ask about it in the deposition. So there is a process, but if the fact discovery needs to be done by July 29th, they need to be able to get into their depositions, which means they're going to need the answers to interrogatories, which I get. So this is an appropriate time to say, yo, we need the court to step in. With an eye to meeting that deadline, plaintiffs served their first consolidated discovery requests in December. Defendants missed the deadline to respond, and when questioned, stated that they did not believe discovery should proceed until the court ruled on their motion to dismiss. I mean, I can understand that, but there's no stay of discovery. After plaintiff explained that there was no stay of discovery in this case, defendants served incomplete and evasive discovery responses. Some people will ask in this, when they file a motion to dismiss, they will ask the court to stay discovery. What that means is the court will stop discovery and say, no, nothing needs to be done. You don't need to go through the time and effort of completing discovery until the motion to dismiss is ruled on. Because if the motion to dismiss is granted, like the motion to dismiss was granted in the Toddy Westbrook case, why go through the process of discovery and give people your shit if the case is ultimately going to get dismissed? So I understand hey, we don't want to respond until the motion is ruled on. That's a reasonable thing. But you have to ask the court to stay the discovery in a formal way. Otherwise, the deadlines still apply, and the plaintiff is the one that can be most penalized by not getting the discovery to go, because they're the ones who have to prove the case at the end of the day. The defendants are generally not as prejudiced by not getting discovery as the plaintiffs are. So that's why the plaintiff, in this case, Chrisley, is like, we need discovery, not fuckery. So that's what this motion is about. Plaintiffs explained, we love the sass. After plaintiffs explained, there's no stay here. You need to just give us the shit. After plaintiffs explained that there was no stay of discovery, they were served with incomplete and evasive discovery responses on January 17th, beyond the 30-day deadline imposed by the Minnesota rules, and have subsequently refused to supplement those responses. In the 3 months since then, defendants have produced only a small number of documents, most of which are images of publicly available materials, and some which are not clearly responsive to any of the discovery requests. Defendants' failure to fully and timely provide or respond to plaintiff's discovery may require plaintiffs filing a motion to compel, which is what they did. However, the first available date on which the motion may be heard by the court is July 20th. Which is roughly 1 week prior to the proposed close of fact discovery. Accordingly, plaintiff requests the court to schedule an informal telephone conference at its earliest convenience to set a briefing schedule to resolve these discovery issues, which are set forth in more detail below. So let us get into that more. Defendant's failure to respond to interrogatory number 3. Tell us what interrogatory number 3 is, because that's going to be the question that needs to be answered. Tell us. As context for this request, it is important that the court understand the factual genesis of the case. We've already read the complaint. We know the factual genesis of the case, but we'll do it anyway. I don't know why I'm whispering. Plaintiff Todd Chrisley, and I know his full name is Michael Todd Chrisley, but his show's Todd Chrisley, and it feels weird to say his full name. I don't know why. Todd Chrisley is a real estate investor and star of USA Network's reality television program, Chrisley Knows Best. He also has a podcast, Chrisley Confessions, that is spicy. The podcast is spicy. It's entertaining, but it is spicy. The program follows Chrisley and his family. Defendant KJ is an internet personality with a focus on reality television. Through the company, Without a Crystal Ball, she monetizes her social media presence on YouTube, Twitter, Instagram, and Facebook. It's funny that this is roughly the same way it's described in the 7M lawsuit. Publicly claims, I wonder how I imagine sorry, y'all, as my camera buffered live. I'm going to start calling my tangent sidebars. We're just going sidebar. You and me, we are going sidebar together. So sidebar. I imagine that the lawyers in all of these cases are looking at what the other lawyers have filed. I wouldn't be surprised, and I want to go back and look and see like a murderous conspiracy or monuments to the gods of speculation. We'll know there's inspo, but I'm sure the lawyers in the 7M case, if they are smart, and I imagine that they are looking at the filings in this Chrisley case and are looking at the other filings against the common defendant. So with that, if I am buffering you guys, please refresh. I am sorry if I am. I apologize. Try not to buffer. So with that, I imagine that these lawyers are looking at what the others have said and what the others are filing, because we're seeing that defendant monetizes her social media presence is almost the exact same sentence that's in the 7M lawsuit. So even if they are not working together, they are probably working together. You know, inspo, reading what others have said, reading what the other cases are, exactly that. So, Paulson publicly claims to be a close friend of Mr. Chrisley's daughter, Lindsay Chrisley. Look, I am aware that stuff has happened on social media with regard to Lindsay Chrisley. I do not follow it closely. All if there are Reddits about this that are going to have way more information than I do. But Lindsay Chrisley has said that she has asked a YouTuber to stop talking about her. So there is context for this, and I actually know some of the context in this one. I have paid no attention to the context in the 7M case, so I always make it clear where I have paid attention to context and not paid attention to context. Paulson publicly claims to be a close friend of Chrisley's daughter, Lindsay Chrisley, who appeared on Chrisley Knows Best for several seasons until the network declined to include her in future seasons of the program. At that point, Lindsay became estranged from her father and the rest of the family and lashes out at them on social media. Lindsay appeared on the daytime talk show Dr. Phil on October 17th, 2019. She recounted a meeting with Mr. Chrisley during which Chrisley allegedly told her that Chase Chrisley, her half-brother, had obtained a adult behavior tape featuring her and a man other than her then husband for $5,000. Lindsay Chrisley agreed when asked by Dr. Phil that she viewed this as a veiled threat related to her cooperation with law enforcement and its investigation of Mr. Chrisley and the rest of her family. This account of the meeting was inaccurate and there was no such threat. That's what they say. But there is an interview. There is a Dr. Phil interview. They say Paulson spent 2 years following this interview spreading, embroidering, and expanding upon the defamatory falsehood that Mr. Chrisley attempted to extort his daughter by threatening to release a sex tape featuring her if she refused to lie to authorities investigating the family. So her saying she took it as a threat and then someone turning around and embellishing that is going to be a problem. And we saw that with the Cardi B Tasha K lawsuit, right? Because Tasha K had someone else on her channel who gave an interview and said all this shit about Cardi B, and then Tasha K kept running with it. If it had just been that interview, you sue the person who said the thing, and you ask the channel to take it down. And if they don't, you sue them for leaving it up. But that's it. But if they keep going, which is what happened with regard to Tasha K, she kept going on those statements with knowledge of their falsehood. And that's what has to be proved in the defamation cases. So to say, look, you can accurately report what was said. You can accurately, the document alleges this. But if you start extrapolating off of it, then you're not just re-reporting what was said. Then it changes and becomes or potentially defamatory, I should say, not necessarily defamatory, potentially defamatory. So I see you guys talking about the likes. Thank you for remembering to like. And if you're new, go ahead and do the YouTube subscribey things if you would like. So you are reminded when I go live and do the things. Let's continue, shall we? So that's why the embellishing and exaggerating and extrapolating can be defamatory, even if it's saying something that's real. Hopefully that makes sense. Let's see. In particular, 2 days after the appearance on Dr. Phil, Paulson published a YouTube video falsely claiming that, quote, somebody anonymously from the Chrisley Knows Best crew actually reached out to me to let me know that they watched Lindsay Chrisley's interview on Dr. Phil, and they said, I believe her. I'm not even lying. I mean, when we get to a statement of fact, the I'm not even lying is one of the things. Plaintiff's interrogatory number 3 focuses specifically on Paulson's claimed conversation with an anonymous crew member. It requested that she identify any member of the television production crew with whom you've had communicated, including the nature, substance, and date of the communication. Plaintiff made this request because he alleges that Ms. Paulson fabricated this call to bolster the credibility of her false allegations and boost her perceived reputation as a person with inside knowledge. So bragging about sources is really what they're saying. The requested information is particularly critical to plaintiff's case because as a public figure, Chrisley must show that Paulson made the defamatory statements with actual malice, as we know, because we've covered it multiple times in multiple defamation cases with public figures. The circumstances of Paulson's call, or they say Paulson's supposed call with a crew member, go directly to her actual malice because, quote, a statement may have been made with actual malice if it, and we're going to read what the law says. We're going to read what the law says. If it is fabricated by the defendant, is the product of her imagination, is basically or is based wholly on unverified anonymous telephone call, or if the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation. And that is coming from case law that they are citing from Minnesota from 2003. And that's the thing. You can't just, if somebody calls you and says wild shit, then you can't just publish it. It's why journalists verify in multiple ways. Hey, if they talk to a source, how can you back this up? Generally, they have multiple sources to verify a fact, because verifying something on one statement of fact is generally not up to journalistic ethics and standards. You have to independently verify something. This goes for criminal prosecutions as well. Somebody can say, no, listen to this. And you're like, okay, but also, how do I prove that? And that's when you end up with phone records and emails and other things that can back things up and other things that can prove the thing. Apparently my audio is buffering a little. Sorry, guys. How many tech issues can we have? How many? No, we're not going to sing how many fucks. How many tech issues can we have? Zero. No, we can have lots. We can have lots. Hopefully this will help. So thank you for letting me know, you guys. Let us continue into this. Let us continue into the motion. So They say that KJ largely refused to provide the requested information, stating objection. And again, you are allowed to object to interrogatories. It's not unexpected. Like that's what you're doing. Like that's what you're doing. You're objecting to things. That's what you do. Objection calls for information protected by the journalist privilege outlined in Minnesota statute 595.021-025 and the Cervantes versus Time Inc. case, which is a federal Second Circuit case. Subject to that objection, defendants never received the name of the person with whom they were in contact. What? Okay. What? But what? Paulson's response frustrated Chrisley's effort to obtain the discovery necessary to demonstrate that Paulson did not receive the claimed call from a member of the crew. In particular, it did not include information concerning the circumstances or substance of the call or any detail as to Paulson's efforts to confirm this individual was a crew member. So they are relying on journalistic privilege and a case with regard to journalistic privilege, but then also saying, yes, we object, but also we don't know who we talked to. What? Never received the name. How do you verify a person worked in a place if you never received their name? Like, how do you independently verify when somebody says, I work here, if you can't verify that they're at least a crew member? You verify that before you publish it. Okay. And then and we can look at the journalistic privilege in Minnesota if you guys are interested, but most of these things protect sources that aren't published or notes that aren't published. But also, it will be interesting to see what the court does with this objection. It doesn't mean it can't extend into the online space, but it will be interesting to see what that case said. Of course, this is the plaintiff's motion, not the defense's motion, so we don't have their full fleshed out argument. But what they are saying is that this is all they're saying the response was. There's not much more of a response there. Paulson's response frustrated Mr. Chrisley's efforts to obtain the discovery necessary to demonstrate that Ms. Paulson did not receive the claim call or to confirm that they were a crew member. All right. In subsequent correspondence, Chrisley's... I'm not done with this. I thought I was done, but I'm not done. Here's the thing. The other thing is, if you're going to talk to someone like on background and you're not going to put their name in the article, then you have to verify with someone else. You can get the background information, but you can't run it. You have to verify it in another way. So you're like, okay, I have the information. I know I'm going down the right path, but then how do I verify it? You can't talk to someone on background and then publish it based on them as a source. That's not how that works. Laura M. That comment is iconic. Okay. That's the end of that sidebar. Let's continue. In subsequent correspondence, Chrisley's counsel explained in detail. I love that their counsel's like, we keep having to educate them about how this works. I feel like this whole motion is like, but we told you that's not how that works. But we told you that's not how he works. But we told you that's not how that works. In subsequent correspondence, Chrisley's counsel explained in detail why the privilege defendants invoked does not apply and requested that defendants supplement their response. Defendants refused. This is a proper consideration for the court to determine. Chrisley's counsel then responded by email and requested to meet and confer. Plaintiff did not receive a response. So they're telling the court, look, we have tried to resolve this ourselves and we can't. This is a proper thing for the court to resolve. This is exactly what the court does. This is exactly what they do. So they go in and they verify. Without receiving a complete answer from Paulson on the interrogatory number 3, Chrisley's efforts to provide to prove that there was actual malice will be significantly inhibited. Chrisley can only assume that she will respond similarly to any deposition questions. Thus, KJ must be compelled to supplement this response. Defendant's failure to produce documents. I'm going to sidebar for a second. I'm going to tell you guys a story. We were out at karaoke last night. The room was very dark. You know how much I love a glossy lip. The Gerard Cosmetics, I call them lightsaber lip glosses. That's not what they are called because trademarks are real. Has a mirror on it and a light. And today I had let somebody else like see it for sure. And other people there were like, you've got to tell me what that is. Because again, when you're in a dark, was it a club karaoke bar? The fact that you're lighting up the lip and then being able to put on gloss was just, it was so epic. And people were like, what is that? I love, this one's pink frosting. I love it so much. So anyway, there's a code. Nightbot puts up a code for Gerard Cosmetics. If you want to check it out yourself, it's so good. So anyway, today, Octo and I were talking about that when he was like, oh my God, people wanted the information. I was up singing and people were asking for the code for the Gerard Cosmetics, but I love it so much. All right. I realized we have like 4,000 people and I had to explain the lip gloss. We needed more gloss right now to get through this shit. Like there's not enough lip gloss in the world for this. Defendant's failure to produce documents. This is part of discovery. By the way, this is part of discovery, that there are objections, that they go back and forth, and that the court has to resolve it. It is not absolute fuckery. It is part of discovery. So I know for some of y'all, you're like, this feels like fuckery. What's up, Jen Gerard? You heard us talking about you. No, I know you're a law nerd and that you're here. We love you, Jen Gerard, and we love your products. So with that, this is not, I know it feels like fuckery. This is how this process works, and the court is going to have to deal with this. And that's absolutely fine. That's what this is. But with the deadlines adhering or rapidly approaching, I can understand why they are now making a motion to the court to do this. But again, the journalistic privilege is kind of sending me. I got to be honest. Like it's sending me. Failure to produce documents. Defendant represented in their correspondence dated March 11th, 2022, that they continue, quote, to work on production of documents. Like you have them or you don't. You have them or you don't, though. You have them or you don't. If there are DMs, the DMs are what's going to be turned over. Okay. Work on production of documents requested by plaintiff in December 2021. There are time limits for these things, so I get it. But another month has passed and defendants still have not produced a single additional document beyond their facially deficient initial production. By plaintiff's count, the grand sum of defendant's production consists of approximately 60 files, 5 videos, 35 pictures, 7 screen captures, and 3 documents. Defendant's production does not include any of the documents responsive to 6 of the 10 requests for production served by plaintiff. Essentially, every request that required KJ to provide non-public information. Footnote 1. Oh, there is quite a lot in footnote 1. Excuse me. Excuse me. Excuse me. Karaoke voice, I need you to behave right now. I need you to behave so we can do footnote voice, okay? Well, Emily, if you would like your voice to behave, maybe don't scream WAP at the top of your lungs with Zach Peter in a karaoke bar. Maybe. But maybe not. Okay. They are RFP number 2, communications Ms. Paulson has regarding or referring to Mr. Chrisley. All communications? It's probably a few more than 5. Request RFP. Sorry. Let me back up my brain. RFP means request for production. They're numbered. So it's like, give me this, give me that, give me this, give me that. RFP number 3, notes, drafts, journals, or other documents relating to or referring to Mr. Chrisley. Some of that might be discoverable. Some of that might not. This needs to go to, again, a judge will have to determine some of this. RFP number 6, documents sufficient to show engagement with Ms. Paulson's social media posts regarding or concerning Chrisley. That's completely fair. So all the back end data, all of the analytics. I mean, the analytics aren't going to be privileged. So anyway, those are just it. So RFP document number 7, documents sufficient to show compensation derived from Ms. Paulson's social media activity. RFP number 8, documents sufficient to show the corporate structure and organization. Again, you're not going to get away from that either. That's just discoverable. RFP number 9, documents sufficient to show income derived. Also, you're not going to be able to get away from that one. The only one that there might be some objections to that the court will have to take or should have to take a look at would really be notes, drafts, journals, or other documents. I would absolutely, if I'm on defense, I'm absolutely objecting to that and making the court make me turn it over. But the rest of it, or do a partial, like these are the drafts. Like if you have a Word document where you're writing things out, like these are the 3 drafts before and I edited it. But engagement and analytics are going to have to get turned over. Corporate structure is going to have to get turned over. Income is going to have to get turned over. Defendants made boilerplate objections to each of these and stated, quote, subject to these objections, to the extent defendants have documents responsive to this request that are within the scope of the rules, discovery is ongoing and will be produced according to defendants' obligations under the rules. It is unclear whether defendants have completed production of responsive documents in their responses. So they're like, so do you not have any other documents or what is happening? I understand the request there for sure. Because again, analytics will have to get turned over. On March 15th, 2022, plaintiff requested that defendants meet and confer as to the status and timing of defendants' ongoing document production, given that more than halfway through the discovery period contemplated by the parties' proposed scheduling order, defendants have produced virtually nothing. But defendant ignored this request too and have continued to withhold documents. Because of defendants' obstruction of the discovery process, plaintiff has no recourse but to request the aid of the court. Based on the foregoing, Chrisley request the court schedule an informal telephone conference to set a briefing schedule so the court can intercede here. This question caught my eye. Who is Kate? Hello? No, who said Kate? My brain flipped that all around and I feel like we know each other because I see you in the chat all the time and my brain still flipped around. Boilerplate objection really means it is just a copy and paste standard answer, like same answer to everything. So boilerplate is a legal term of art to mean same, really. It's a literal, like, this is just a standard objection that you copy and paste to things. So, all right. That is the end of this one. Let me get to the next one. Let's go to our next. So that was the notice of motion and motion correspondence. We also have, let's see, is this the same one? No, this is a new one. All right, this is a new correspondence to the court from 2 days later. So that one was filed on April 11th. This one is filed on April 13th. Let's go through this. Dear Judge McPherson, Todd Chrisley writes in response to the letter from defendants dated April 12th concerning the upcoming hearing on defendant's motion to dismiss. Hold on, let me see if we have that letter real quick. Because I don't see it. This is the discovery one. This is the motion to dismiss. This is the opposition to the motion to dismiss. That's discovery. Here it is. All right. This is filed. So this is what's filed in the intermediary time from KJ's attorney, Martin. And this was filed on April 12th at 3 p.m. Dear Judge McPherson, after being served with plaintiff's summons and complaint on this matter on October 18th, 2021, the defendants in this matter responded with a motion to dismiss under Rule 12 of the Minnesota Rules. Initially, the hearing on that motion was scheduled for January and subsequently moved to April. The motion is currently scheduled to be heard on April 27th. So that would be coming up at the end of not even at the end of this month, but in a week or so. a week and a little. The plaintiff currently is scheduled a federal criminal trial starting May 16th. Okay, well, that's after April 27th. Well, that case regards charges of tax evasion, a number of the tangential issues regarding the witnesses, including Chrisley's daughter and her interactions with various tax authorities regarding her father, regard news items forming the basis of the bulk of Chrisley's causes of action against Paulson. Again, if you are relying on publicly available information, it must be accurately reported for it to be covered by some of these privileges. And again, we already talked about that. Because witness testimony and the federal courts and jury's findings of fact in the criminal case may bear on issues relevant to this proceeding, Paulson or KJ requests the courts leave to reschedule the hearing on the motion to dismiss until the conclusion of the criminal case so that any relevant findings of fact may be considered by the parties and the court in this matter. I don't know if that's going to help. So plaintiff's trial, the Chrisley trial in the U.S. versus Chrisley, is scheduled to start May 16th. Let me know if you have any questions or concerns. And now let's go back to the response. So that's a request for extension of time. Like, hey, his tax trial's starting. That's something that's being alleged here, even though the sex tape thing seems to be the bulk of this, not the tax stuff, but it's in there. That's accurate. That's in there. So let's now go back to their response. Womp womp. Plaintiff Todd Chrisley writes in response to the letter from defendants dated April 12th, 2020, concerning the upcoming hearing on the motion to dismiss, April 13th. They're probably going to argue that the trial is not relevant on this at all because the trial doesn't change anything. Sidebar. The trial doesn't change what was said. Like what happens coming up doesn't change what was said at the time. So with the information known at that time, I don't think what happens now changes shit that was said back then. Let's see if that's the direction they go with this. Are these a first look? Yes. Yes. I was running around Nashville for 3 days. This is absolutely a first look. Defendants request that the court delay the imminent hearing on their motion to dismiss pending the conclusion of the upcoming trial, United States versus Chrisley. Defendants apparently concede that case concerns subject matter unrelated to this litigation. While defendants contend that tangential issues may be addressed during the trial that may bear on issues relevant to this proceeding. Y'all know what I love about this. Tell me what I love about this. Chat, just tell me what I love about this so much. What do I love about this so much? Yes, when you use someone's arguments and words against them. That is one of the things that lawyering is foundationally based on. It's like, well, you said this and this means that. May bear on issues relevant to this proceeding. Defendants neither explain nor support that assertion. It is unclear how this trial could impact defendants' motion to dismiss. As detailed in plaintiff's opposition, the arguments raised in the motion fail as a matter of law, regardless of what transpires at the upcoming trial. That's kind of what I was thinking. Moreover, the trial date in the above case was set months before defendants filed their motion to dismiss and secured an upcoming hearing date. Oh, so they picked the date knowing what was happening. Defendants were plainly aware of it. Indeed, they noted the trial date in their memorandum of law supporting their motion to dismiss. Well, that's not going to go well for them. That's not going to help. If the trial date has been set as federal trials are, if the trial date was set and noted in that motion, you're not going to get a continuance now because you, A, already knew about it, B, it hasn't changed, C, it's not relevant, and D, the court's going to be like, but you picked the date, though. Bruh, if you pick the date, you don't get to just change it. Nothing has changed since then except plaintiffs started to pursue discovery. And as explained in plaintiff's recent discovery letter to the court that we just covered, defendants have attempted to justify their refusal to meaningfully participate in discovery by reference to their unresolved motion to dismiss. This recent effort to delay the upcoming hearing, which defendants initially sought to hold at the earliest possible opportunity, raises concerns that defendants will continue to cite their unresolved motion as a justification for their refusal to honor discovery obligations. So they're saying delay, 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 delay. Accordingly, while there's no need to delay the resolution of defendant's motion to dismiss, should the court reschedule the hearing on that motion, plaintiffs respectfully request the court utilize the time reserved for the hearing to hold a conference on the discovery disputes raised in plaintiff's discovery letter. I mean, I think that's fair. Let's see. I think we've got one more. But again, they point out, they make an excellent point in that argument. It's like, bruh, you knew. You're not getting a continuance. And they're arguing that this is now becoming a delay tactic. So I'm not surprised that they're arguing it. Let's look at the opposition to the motion to dismiss real quick, and then we will go to questions. Delay always benefits the defendant in civil case and doesn't benefit the plaintiff, because the plaintiff has obligations and a trial date that's coming down the road. So you got to do it. So, plaintiff's opposition to defendant's motion to dismiss. Defendants, KJ, and company have monetized a years-long campaign of lies. Well, now we've got a years-long campaign of lies. This is a motion. This is a trial. This is a case. This is a lawsuit. There it is. This is a lawsuit based on the defendant's greed. And now we have a years-long campaign of lies. I like a years-long campaign of lies. It has a certain ring to it. Company has monetized a years-long campaign of lies directed at plaintiff. In particular, they have repeatedly accused Chrisley of 1, attempting to extort his own daughter by threatening to release a tape featuring her and a man other than her then husband if she would not lie to criminal investigators, and 2, attempting to extort KJ herself. Not really related to the other stuff. Defendants have used these salacious falsehoods to drive traffic to their social media outlets, broadcasting them to an audience of thousands in order to reap the resulting ad revenue. Chrisley now seeks through his lawsuit to hold KJ to account. I appreciate the double spacing in a way that none of you will ever know. Defendants have responded with a motion to dismiss that attempts to rewrite the rewriting history. Attempts to rewrite not just the defamatory statements at issue, but also controlling law. Not rewriting the statements. And that's interesting because we see it in the H3 case as well. In the defendant's motion in the H3 case, they keep, and I keep pointing this out in their motions, but this is a defense tactic. It's like H3 said, Cav was accused by his business partner of blah, 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 blah. And then in the defense motion, they keep saying, Ethan Klein said that Cav was running a Ponzi scheme, blah, 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 blah. And we talked about the difference between accused by and running and that's rewriting the statements a little bit. And in that case, trying to make them look, well, Kavanaugh's the plaintiff, but the defendant in the anti-slap, trying to make the statements appear worse than they are. So it's interesting to see them saying here that they feel statements are being rewritten. Their motion raises a series of issues typically left to the jury to decide and fails to cite even a single case involving defamation that was resolved on a motion to dismiss. Defamation cases can, though, be resolved on motions to dismiss. That it can happen. Defendants first contend that their fair and accurate reporting privilege shields KJ's falsehoods, but the privilege does not apply because, among other things, none of the defamatory statements report on or further argues that Chrisley must, at the pleading stage, come forward with, quote, evidence proving that her alleged defamatory statements are known lies. They say not so. Chrisley need only plead as he does that Paulson knew her statements were false or that she acted recklessly in making them. I think that accurately recites the the pleading standard, because again, this is a pleading standard. This on a motion to dismiss, and this is a motion to dismiss with regard to facts, not a motion to dismiss with regard to like jurisdiction, as we've seen before. With that, we need you. The buffering is real. On the stand, my brain is also buffering tonight, but that tired. You take everything in the light most favorable to the plaintiff. So the pleading standard is fairly low. Light, most favorable to the plaintiff. If everything the plaintiff said is true, it still doesn't hold water. That's what they're looking for in a motion to dismiss, in this type of motion to dismiss. And so for them to try to shift the burden in a motion to dismiss isn't accurate, because you take everything in light most favorable to the plaintiff. So we are assuming, for the purpose of a motion to dismiss only, that everything Chrisley said in his complaint is true. And from there, then you decide if there's enough. So you don't get to change it. So you don't get to change the pleading standard. They say KJ also contends that isolated phrases from her social media post accusing Chrisley of extorting her are literally true. Okay, well, if you're saying that they're literally true, that's fine. Are they defamatory or not? They say that it's axiomatic. I've heard it both ways. Tell me what you like in the chat. Axiomatic or axiomatic? Do we go with the E in the middle with the I? Anyway, but it is axiomatic that, quote, the defamatory character of any particular statement must be construed in the context of the articles as a whole. Which again is what we're seeing. I shouldn't say again, because I haven't made this comparison yet. That is what we are seeing in the Depp Heard case. How many defamatory cases do we cover? Emily, does your channel just cover defamation cases? No, but that's like literally what's happening right now in the world of pop culture. They're also very interesting to parse. So many defamation cases. In the Heard Depp case, you have the isolated statements, but they also are talking about the op-ed as a whole, because you have to talk about it as a whole as well. You get both. Continuing on, they say the fact that individual phrases are true does not relieve them of liability when in context they plainly accuse Chrisley of criminal activity. This is where we get into the defamation by implication that you see in some of the cases that we've talked about, including the Depp case where he's never named. Accordingly, they say the motion to dismiss should be denied. Background: plaintiff is a real estate investor and star of USA Network's Chrisley Knows Best. The program follows Chrisley and his family. His oldest daughter, Lindsay Chrisley, appeared on the show in a reoccurring role until its 5th season, at which point the network declined to include her in future seasons. She blamed her family and her father for her exclusion from the show and lashed out on social media. This talks about Dr. Phil, which we just talked about in the other motion, so we're not going to repeat the exact same sentence. They talk about who KJ is again, which they talked about in the last thing, as they kind of rehashed this in the next motion. They talk about the public claims about being friends with Lindsay Chrisley. Here are the false statements that they are alleging that were in the complaint. They're alleging again on October 19th, 2019, Paulson posted a now deleted YouTube video lasting more than 45 minutes in which she speculated at length that Mr. Chrisley was involved with a plot to extort his daughter. Ms. Paulson stated that Chase Chrisley and, quote, possibly Todd were coercing Lindsay and Robbie. The assumption here is that Chase was attempting to obtain any videos or nude photos that he would have of Lindsay in an effort to leverage over her in order to threaten her to cooperate with the investigation. In another now deleted YouTube video from October 19th, 2019, so same day, Paulson falsely claimed, quote, somebody anonymously from the Chrisley Knows Best crew actually reached out to me and let me know they watched the interview on Dr. Phil and said, quote, I believe her. I'm not even lying. They say that she goes on to falsely claim that Todd Chrisley approached Lindsay and told her about the nude photos and a video that her brother had obtained for $5,000, and that she needed to be careful about what she said or things wouldn't end well, with the implication that the PR team might leak the story with containing those nude photos, or that she was having an affair with a Georgia state official. In another YouTube video dated October 23rd, Paul said, I'm getting weather warnings. Maybe that's what's going on with my internet. Sorry, y'all. The only alerts I have in my phone are weather, because I'm a nerd, and B, weather's interesting. So we've got possibly weather is the problem. That's a lot of weather alerts. All right, well, more weather. Not as much weather as we had the other night during Spilling Tea Live. They got all of the weather. All of the weather. All of the weather. All right, let us continue. In another YouTube video dated October 23rd, they say KJ again stated at length that the allegation that Chrisley, quote, threatened to release the tape if Lindsay Chrisley did not cooperate. She further stated in tweets that Chrisley had posted much earlier were, quote, clearly threats that he's going to release the tape. In a January 5th, 2020 YouTube video, Paulson again repeated the allegation that Chrisley attempted to extort his daughter with a sex tape. She stated, among other statements, quote, who would want to read stuff from a father that is constantly saying negative things about you, and hell, threatening to release trying to buy a tape between you and your ex because they're mad at you because you won't lie to federal prosecutors, or federal prosecutors really into an investigation into his alleged tax evasion. That statement is rough, but I feel like that's probably a direct translation. In a series of tweets dated June 25th, 2020, they're saying KJ again repeated the falsehood that Chrisley threatened his daughter with releasing a sex tape. And then they're going on tweet, Facebook post, Instagram post, which is why they want in discovery all of the analytics, and which is why they're asking for it, because the analytics are part of their case and part of discovery. So those are all the statements. They're saying that these false statements were broadcast to an audience of thousands, despite knowing them to be false. She did so to strengthen her relationship with Lindsay Chrisley and to drive traffic to her social media accounts for her own financial benefit and that of her company. They're alleging that KJ knew the statements were false based on her relationship and regular communications with Lindsay Chrisley. That Paulson further understood the sensationalistic, improbable nature of the allegations. They say KJ also knew that she had not received inside information anonymously from a crew member or from Lindsay. They say that she eventually removed a number of the publications at issue from her various social media pages, again demonstrating her knowledge of the falsity. They go through another series of social media posts and statements, and then the legal standard for the motion to dismiss, which is under Minnesota's libel written defamation, liberal notice pleading standard, a Rule 12.02 claim, which is basically a 12b6 motion to dismiss. Rule 12.02 motion to dismiss for failure to state a claim will be denied if it is possible on any evidence which might be produced consistent with the pleader's theory to grant the relief demanded. So, is it possible that these things are defamatory based on the way it's pled? Yes, it's possible. In determining whether the complaint sets forth a legally sufficient claim, the court must accept the facts alleged in the complaint as true and construe all reasonable inferences in favor of the moving or the non-moving party, meaning the plaintiff. As we discussed earlier, almost like I am a lawyer with experience and knows how to, personal law and stuff, but that's the standard on a motion to dismiss, and that's pretty basic. Argument: the fair and accurate reporting privilege does not apply. Generally, the common law republication rule, quote, provides that a speaker who knows or should know that a statement is false and defamatory but speaks it nonetheless is equally as liable for the defamation as the original speaker. CEG, Cardi B. Defendants first argue that Paulson's statements fall within the fair and accurate reporting privilege. I think the accurate is the operative The way this internet's behaving right now. I was bragging on this internet for days, Tennessee. I was at a conference talking about how much better the internet is in Tennessee, but I get it. Weather makes it hard. It's an exception to the common law republication rule and an affirmative defense. It shields from liability one who publishes a, quote, accurate and complete report or a fair abridgment of public proceedings or public records that would otherwise be defamatory. Sorry, my nose is itching me. Something absolutely terrible. My nose is I have to scratch my nose. I have to. Sorry, y'all. Nose is itchy. We're back. They say that defendants, KJ, contend that the privilege applies here because KJ's defamatory publications are drawn almost wholly from a police report and a televised interview with Lindsay Chrisley and Dr. Phil. And again, if it is, and here's what it's going to break down to, if it is an accurate recitation of what happened on Dr. Phil, it's not going to be defamatory. Lindsay Chrisley went on Dr. Phil and said this is exactly analogous to Ethan Klein saying Kavanaugh's ex-business partner alleged this. If the statements are extrapolated or embellished, then it doesn't apply. Hopefully that makes sense. If they are same, we're in the same position as we are in the H3 case. So that, and you guys can look at the statements that are alleged here. These cases are all public record. And the interview with Dr. Phil is also public record. So you guys can take a look. So, okay. You guys are like, it makes sense. Good. I'm glad it makes sense. Let us continue. They are saying, again, this is Chrisley's opposition to the motion to dismiss, is saying that factual premise is incorrect. They say none of the statements at issue summarize or abridges any police report. Only a few ever refer to Lindsay Chrisley's interview with Dr. Phil, and many rely on or summarize other non-privileged sources, such as various social media posts by Lindsay Chrisley. Moreover, defendants' defamatory claims that Chrisley attempted to extort KJ herself are completely unconnected to the cited police report and interview. My voice is like, are we done yet? Defendants make no effort to explain how the fair reporting privilege attaches to any particular statements at issue. They simply invoke this affirmative defense and leave it to Mr. Chrisley and the court to puzzle out how it might apply. Even if Paulson's reporting did summarize or abridge a police report made by Chrisley, the fair reporting privilege would not apply, as the restatement explains, and this is the restatement of the privilege, quote, an arrest by an officer is an official action, and a report of the fact of an arrest or the charge of a crime made by an officer in making or returning the arrest is therefore within the conditional privilege covered by this section, restatement second of torts. In stark contrast, statements made, quote, by the complainant or other witnesses outside of the public proceeding or official statement, such as Lindsay Chrisley's complaint, quote, are not privileged under this section. So they're saying her statements are not privileged. The fact of a thing is privileged. And it might seem like a differentiation without a difference. And I'll be interested to see what the court says about it. But for me, the differentiation is, hey, so-and-so was arrested is a statement of a fact versus this happened. Like the extortion happened is different than someone was arrested for a particular charge. It is a difference. In this case that they are citing, this Jones case, it says, we conclude that unofficial statements made by police sources are outside the scope of the fair reporting privilege. They say only reports of official statements or records made or released by a public agency are protected by the privilege, distinguishing statements protected under fair reporting privilege from those made in informal interviews or private conversations with arresting officers or investigators. This is because, quote, such reports to police are unverified hearsay rather than official statements by state officials. So again, they're not protected because it's hearsay. That means in sum, that it's on the person that's going to retell it to verify its veracity or not. Notably, they said the Minnesota Supreme Court cited Jones with approval in its leading case concerning the fair reporting privilege. They're citing quite a lot of law. And the Minnesota Supreme Court has also constantly followed the restatements approach in delineating the limits of fair reporting privilege. They say that KJ's reporting regarding Chrisley's interview on Dr. Phil likewise fails to trigger the fair reporting privilege. So they're saying it doesn't apply to a TV interview. They say, indeed, defendants acknowledge as much, admitting with considerable understatement that, quote, there may be some disagreements as to the application of this privilege to the Dr. Phil interview. So they're saying that disagreements is a significant understatement, that the court doesn't apply. They say that the fair reporting privilege applies solely to reports of governmental proceedings and public records. Minnesota courts have taken an incremental approach in defining the privilege and have applied it only in limited circumstances involving governmental proceedings or statements. The undersigned is aware of no authority applying the fair reporting privilege to statements made on a daytime talk show. Defendants cite no such authority, nor do they otherwise provide a legal basis for this court to expand the privilege far beyond its recognized bounds. Footnote 1. Defendants assert in passing that Mr. Chrisley's Miss Chrisley's, wrong Chrisley. Letters are hard. Defendants assert in passing that Miss Chrisley's false accounts of a meeting with her father on Dr. Phil consist of, quote, statements made by the eyewitness whose account has presumptive veracity. No, it doesn't. How does what somebody says on a TV show have presumptive veracity? It's not a sworn statement, which again is a difference here than in the H3 case. In the H3 case, you have a Variety article that attached a statement signed under penalty of perjury. Even though it was not filed in court, it was signed under penalty of perjury. So if you want to talk about presumptive veracity, you can look at something signed under penalty of perjury and go, well, it's signed under penalty of perjury, but just some shit you say on television is hearsay. My throat is killing me. It is unclear why defendants believe Miss Chrisley's falsehoods have, quote, presumptive veracity. Oh, I forgot I was in footnote voice. Apologies. And they do not explain. Under Minnesota Rule 12.02e, the court must credit the allegations of Mr. Chrisley's complaint and presume the opposite. Well, yes, because that's the rule. All of the inferences have to be taken at the benefit of the plaintiff, the non-moving party. We've come to the end of cup number 1 of water. We're moving into cup number 2 of water. Don't worry. We're almost through this, and then we're going to do some questions and super chats before either my voice goes out or I fall over and fall asleep. We're tired. Let's see. They say, finally, even if the publications at issue here summarized or abridged privileged sources, the privilege is lost if one, quote, makes additions of their own that would convey a defamatory impression. And this, again, that's essentially what Ryan Kavanaugh's arguing in his case too. Or imputes corruptive motives to anyone, or indicts expressly or by innuendo the veracity or integrity of any of the parties. And that's a case going through the second restatement of torts. If a defendant ventures beyond summarizing or abridging a public proceeding or a record, the entire report then would be subject to evaluation as any other alleged defamatory statement. They say that KJ's publications include many defamatory additions not found in cited sources. Among other things, KJ claimed that 1, Chrisley himself attempted to purchase a sex tape of his daughter, and 2, Chrisley threatened his daughter with the release of nude photographs in addition to the sex tape. And 3, Chrisley threatened to release the sex tape through social media. They say KJ has also repeatedly opined on the party's credibility, e.g., I believe Lindsay Chrisley, cited additional non-privileged sources to bolster the false story, and speculated regarding Chrisley's corrupt motive, e.g., claiming Chrisley mistreated his daughter because he was mad because Lindsay wouldn't lie to federal prosecutors. This forecloses defendants from invoking the fair reporting privilege, or at least renders the application a jury question. And I think it is a jury question, properly a jury question. The fair reporting privilege is a defense, and a defense is properly considered by a jury because it's fact specific. And so a jury would have to look at the jury instructions of fair reporting privilege and look at what was done and say, does this fairly and accurately recite what happened, recite a public source, or does this extrapolate and add and embellish what was said? It's the embellishment and the extrapolating and the adding where one has to be careful. Chrisley has adequately pled actual malice, and they're saying public figures bringing up defamation claims must show the defamatory was stated with actual malice. I'm going to skip through this because for a pleading, it just needs to say the statements were made with malice or reckless disregard. They don't have to prove all of that in a pleading. They have to allege it in the pleading. The proof comes up at trial. So they're saying it has to be proven. I don't agree with that standard. They say that Minnesota has adopted a liberal pleading, a notice pleading standard under which, quote, a motion to dismiss for failure to state a claim will be denied if it is possible on any evidence which might be produced consistent with the pleader's theory for relief to be granted. So we're not going to go through the law on that section because, again, it's pled that there's actual malice. So that's going to be sufficient for the court on this motion. They say Chrisley repeatedly alleges that Paulson knew the defamatory statements at issues to be false when she made them, or at least acted with reckless disregard for their truth. And reckless disregard is probably where they will lean into. Unlike other cases we've seen, I don't believe, and I can be absolutely wrong, but I don't believe there's any admissions of knowledge of falsity like there have been in other cases, which means it has to go to reckless disregard, being like, hey, this is what statement A said on the Dr. Phil show. And this is what Dr. B said. Are these the same or not? And if they're not the same, then that's the reckless disregard because it's been extrapolated or made up or whatever they're going to allege. So they say that they satisfy the pleading standard. The next header is that the statements that defendants contend are literally true, carry a false and defamatory meaning when read in context. Finally, defendants argue that the individual sentences in the social media post accusing Chrisley of extorting her are literally true when viewed in isolation, but, quote, the defamatory character of a particular statement must be construed in the context of the publication as a whole. They say Ms. Paulson's statements viewed in context plainly carry a false defamatory meaning. And this is where we get into that defamation by implication. It's like what you said might actually not be like plainly defamatory on its face, but it can leave that defamatory impression so that you are my sentence ran away with me because I'm tired. They can leave the impression of a defamatory thing or defamation per se, leaving the impression that someone has committed a crime and things like that. So not saying that that's the example here, but extortion is a crime. So kind of. Statements are defamatory per se if they falsely accuse a person of a crime with regard to, and that's where we've gotten into. We've gotten back to the defamation per se. With regard to false accusations of a crime, the words need not carry upon their face a direct imputation of a crime. It is sufficient that the words spoken in their ordinary acceptance would naturally and presumably be understood in the connection and under the circumstances in which they are used to impute a charge crime. Here, an ordinary reader would understand the two social media posts at issue to impute the false charge that Chrisley committed a felony of extortion by making threats against Paulson, whether or not the individual sentences in those posts are literally true in isolation, e.g., extortion is a felony. As to the first publication, defendants attempt to rewrite KJ's words to Elide. Look at that. Elide? We've the language game is strong in this. The language game is strong. Oh, you guys are saying my audio switched. It has not switched on my side. So I checked, but I have no idea what's going on with audio today. We've been having some internet issues, so I apologize. They assert that the sentence, quote, "Today we serve Todd Chrisley's attorney with a cease and desist for defamation," is literally true and cannot convey a defamatory meaning. But that is not what KJ wrote. Defendants omit the later half of the sentence. The full sentence reads, "Today we serve Todd Chrisley's attorneys with a cease and desist for defamation, extortion, and tortious interference for threats he's made over the past 3 weeks." The tweet continues, "It's against the law to threaten to destroy someone unless they provide private information. Extortion is a felony." You guys can tell me in the chat what you think of the statement. What do you think in the statement? Do you think that that implies that a felony was committed by Todd Chrisley, and that's why they are serving the cease and desist? You let me know what you think in the chat. Does that imply that extortion happened to you? What do you think? The only way to understand this social media post as a whole is that Mr. Chrisley committed, quote, "a felony of extortion by making threats against Paulson." Indeed, that accusation is explicit in the portion of Paulson's tweet that defendants conspicuously omitted from their brief. I'm just going to pull up a sampling of what you guys said. Yes, yes, a felony is implied. Yes, nope. Yes, and we're allowed to disagree. Nope. Implies, but implication is not truth. No, but implication can't be defamation. Does the Pope wear a funny hat? Y'all are not amused right now. Implied, yes. No. I think a felony is implied. Definitely implied. Yes, yes. Sounds like blackmail. So you guys, some of you are like, no, I don't think so. And yes, I do think so. And that's, again, why this will be a jury question, because this is what a jury is going to have to decide, just like you are. Does that imply it or does it not? So a lot of you seem to think so. Some of you are like, I'm not sure. And that's totally fair. It's totally fair to be like, I don't know what I think. So the second publication incorporates the first and is defamatory for that reason alone. It also elaborates on the accusations of the first publication, stating, quote, "Extortion is a felony and punishable by prison time. At this time, we have not reported this to the FBI. Threatening someone to hand over private information or else you will ruin them is extortion and under the law is a criminal felony." Felonies are only criminal. Felonies aren't civil. Why the redundancy? "We take these threats seriously, and Mr. Chrisley is on bond for federal charges related to a 9-count indictment." They say, again, the statements in context plainly convey a false and defamatory meaning, that Mr. Chrisley made, quote, "threats that KJ," quotes, "take seriously, to the point that she considered," quote, "reporting them to the FBI, and that the threats constituted," quote, "extortion and a felony punishable by prison time." What's more is that the language is unambiguous in imputing to Chrisley the charge of, quote, "committing a felony," as opposed to engaging in more rhetorical hyperbole. This is defamation per se. They say, in any event, the statements above are, at a minimum, plainly capable of conveying the defamatory meaning that Chrisley attempted to extort KJ. If words are capable of a defamatory meaning, a jury must decide if they were actually defamatory, and that's true. It doesn't get you in a motion to dismiss. A jury might not agree. You know, you guys don't all agree, and that's exactly right. That's what trials are for a jury to agree. Does it make it sound this way? Is it hyperbole? But that's not what a motion to dismiss is for. A motion to dismiss is more like, and I hate to say it, but it's more like in the Petito laundry case, where it's like, can this even be a cause of action? Can there even if everything is true, even in the light most favorable, can this actually be intentional infliction of emotional distress when somebody has a legal right to not say anything? Like, is this even a thing? And in this case, it's defamatory. So it's not like, is this even a thing? It's, is this a thing that a jury needs to decide? And that's really where we're at with, is this a thing that a jury needs to decide? So that is the end of this. I think we're done. I hope we're done. I want to be done. Is that terrible that I'm like, I want to be done? But for the sake of completeness, I'm going to just make sure one more time that we got all of the new filings. Yes, that was it. We're done. So we'll see what the court does. I will keep checking in on this. I know as things happen, you guys tag me in this because you have wanted me to cover it. And I do. So we will be keeping an eye on it. We started with the complaint in that case, and we will keep going through it because A, now we're invested and we need to see what happens. And B, we talk a lot about defamation on this channel because it matters to YouTube creators and it matters to all creators. When you look at cases like the H3 Kavanaugh case, you're looking at someone, I think, who's maliciously suing over statements that they are shifting. But there are also things in the world that are defamatory, that can damage people, their reputation, their families, and cause them substantial distress and damage to reputation, like in the Cardi B case. So we're going to keep looking at this to see where these things fall. And again, it is necessary to draw those boundaries on social media because people wild out and just say shit and think that it's fine. It's not fine. There are things that are in fact defamatory. There are things that are just mean and not defamatory. So there's a line between the two, between being mean, between saying things that are shitty, between things that are protected speech, and between defamation that hurts someone's reputation. And these cases are how we continue to find what courts consider that line to be, what juries consider that line to be. And then we'll get to question. I think the Amber Heard and Johnny Depp case is going to go a long way in how we see defamation moving forward, though it might be that a jury looks at both of them and is like, y'all wrecked yourselves. There's no reputational damage here. You all did it to each other. So we'll see. And we will absolutely keep covering defamation because it's important to find the difference in what speech is protected and what speech is not protected. Just because we don't like the speech doesn't mean it's not protected. And just because it's speech doesn't mean it is protected. The First Amendment does not protect defamation. So let's get to questions. Let's get to the things. Let's do the things. And then I am going to go rest. I'm married. Questions. I have questions. You have questions. We have questions. There have been over 4,000 of you in here tonight. Don't forget to do the likey, subscribey, YouTubey things. I appreciate you. It helps grow my channel and all of the things. I need to remind you that we do have a Quick Bits channel, and my amazing mod and editor, Miguelina, is in here commenting under this channel to remind you. So we have a Quick Bits channel. I should probably make the Quick Bits channel moderator on this channel. We probably already did. Back in Austin, Texas, did we name the octopus? We have not named the octopus just yet. We have not. So we have not done that. But let me get to a few super chats. I probably need to get to some more lip gloss. Should we get to some more lip gloss? Yes, we should. Oh, that's a mess. I've now made a mess. I've now made a mess because I'm exhausted and just a mess. Let's see. There is a question I just saw that I really wanted to answer, and I don't know where it goes. Okay, we're going to do this one too. I'm going to tag that one. There was another one I wanted to there's another one I wanted to answer. This one. Allie Riley. Hi. What determines if a case goes to jury trial versus a judge ruling? There are a lot of determinations, but in a civil matter, the parties can ask for a jury trial or a bench trial, depending on the nature of the case. But if a case gets stopped, like on an anti-slap, like we saw with Ethan Klein and Triller, if a case gets stopped on an anti-slap, then it stops by a judge ruling before it even gets to a jury trial. You have to request a jury trial when you file a civil case, and you'll see like jury trial demanded, and you'll see them on a lot of cases. I think there was just a jury trial demand in the civil case with regard to the Petito laundry case. That's if it survives all the motions. The court calendars it for a jury trial date. Yes, jury trial date. But you've got to get through all the motions first. So a jury trial date can be set, and then you get to a motion to dismiss, and a case gets dismissed, and it never goes to a jury. So it is based on, you have a right to a jury trial in most types of cases. There are some you don't, but those are asterisk situations in criminal and civil cases, and you request it. But you can request a bench trial, and that can happen in both civil and criminal where the judge just decides. Hopefully that answered and made sense. So let's get to some of the super chats. Thank you all for the super chats. Boppit said hot tea and lemon and honey for Emily. Yes, I did that earlier, and I'm going to be doing that again after this. I was very tempted to have a hot toddy on stream, but I just needed water because I am dehydrated. Not terribly. I did drink a lot of water yesterday. Christina says, I know we'll be covering the Johnny Depp versus Amber Heard. I just found out Eve Barlow has been barred from coming into the courtroom. I have so many questions after yesterday's witness dismissal. Hopefully we covered most of them for you this evening, because I did cover a number of those tonight. So hopefully those were covered for you, because we talked about it. So yes, the witness dismissal was absolutely the right call, because the witness had watched other witnesses, and that is verboten under the sequestration rules. Under the court has orders on it, and it can impact the veracity of a witness testimony and the fairness of the entire trial process. So it is a problem. I worked with Peter, different department. He's tough. I think Peter is fantastic, and we definitely know that he's tough. Siggy Spider says, on behalf of truck drivers, I want to thank you for your long form content. It's perfect listening for the many miles we cover. Siggy, you are so welcome. Thank you for the work that you do. I hope that the chat, and I'm sure that they did, celebrated you, because, all the stuff that we love comes to us because of truck drivers. So thank you very, very, very much. I was actually telling Octo in a conversation, this weekend, we had lots of conversations, but this weekend about a tow truck driver case that I had, where unfortunately a tow truck driver was killed in the course of their work on the road, and that I didn't realize that there was a fairly large memorial to tow truck drivers here in the South. And it was really touching to see how many people reached out regarding that prosecution and how much it meant to them that it was being taken seriously when kind of one of their own had been killed doing their job. Yay Hill, did they apologize for taking down your video? Fuck no. Law and Crime didn't give a shit. They took down the stream, which totally killed the reach and trajectory of the video. And then when they knew that they were going to lose, because they would have, before I even had a chance to appeal it, they released the claim. I don't know if the company they're working with is doing this. I don't know if they're the ones behind the scenes sitting there doing this. I'm not sure who is making or how they're making their claims, but they have wilded out with these claims. And I think that they run the risk, my opinion, that they run the risk of being afoul of the rules from YouTube's own terms of use in abuse of the copyright system. In the copyright system, you have to know you have a valid copyright in it. They know for fuck sure that they don't have a valid copyright in it. So how can they make copyright claims when they know they don't own that copyright? No, they did not apologize. And I am not done with that. Brandy Rose, the hair looks great in the profile pic. I probably say that every time I see your profile pic. Question, have you heard of Incredibly Average on YouTube? He has a series of videos breaking down inconsistency in Amber Heard's stories. I'd be interested in knowing how much of the info would be admissible in court. I am not familiar with the videos, so it's hard to say what would be admissible. If they are her own statements, they can be admissible for impeachment depending on where they were obtained and how. If they're like her depositions and stuff, then those are absolutely admissible. So it really depends on what the statement is, but it's a 6-week trial. A lot is going to come in. But yes, I'm aware of the inconsistencies that have been pointed out, and Depp's team will be going into that. And I'm sure when Heard testifies, there will be days and days of that stuff. Thank you for all your work, and thank you for being you. You're welcome. You are welcome. Is this Amber's team strategy to confuse the jury so they go the anti-slap course? Steve, I don't think that the team is trying to confuse the jury with regard. I think we were talking about the witness being excused. I think that was just they're protecting their case and their client. The jury is going to have to look at the anti-slap defense in Virginia. It's going to come up in jury instructions. When we get closer to jury instructions, I'll talk about it more, but that's going to come up no matter what. Jury confusion is going to come up no matter what. It's going to be 6 weeks is a long time and a lot of information to take in. Luna Wolf, thank you. Have you seen the James Corden video and allegations? If so, any thoughts? I have no idea what that is referencing. So unfortunately, I don't have thoughts. Jason said, I find this trial very sad for each person with all this dirty laundry coming up. Same. I hope it's quick so both families can move on and start the healing process. This is not going to be quick with Depp and Heard. 6 weeks is a very long time. This is going to be a very, very mudslingy. Jen Gerard, good to see you. Love you, Ponards Need Tuna. I know they are up with Travis this evening, and I'm bummed. But I got to hang out with the Ponards when I got home today. But yes, Fred is out with Travis. I'm surprised he hasn't busted his way in here yet, but he has not. Haley said, please stop her. It hurts us all. You're too good for her everywhere. I'm not sure what that's referring to, but thank you for the super chat. Are you going to cover the Ghislaine Maxwell case? Tammy, I've covered it quite a lot. So there is a playlist with the other stuff that's related to that. The other individual that used to be a prince related to that. Those are together on a playlist here. So I have covered it, and I will cover sentencing in June, but there's not much else to cover until then. At this point, there might be more stuff. Thank you for the super sticker. Snacks for the Ponards. Thank you so much. Kelly B said, can she just refuse not to say who called her? I'm sorry. Isn't that what Discovery's for? Doesn't she have to turn that over? Kelly B, this is going to be relating to KJ and the journalistic privilege. I think it's fair to have the court decide that, because their argument is going to be, I don't have to reveal my sources, but the journalistic privilege is going to apply to things that are not published and notes that are unpublished. Once something's a published source, some of that stuff may have to be disclosed, but I think it's fair to make the court make you turn it over. I think that is a solid defense strategy. It's annoying to the plaintiff, but I think that is a fair defense strategy to object to it. I think it's interesting that the partial response was, we never got a name. That's an interesting direction, because there might not be, they think it was made up. So they're going to try to pin it down a little bit more, and we'll see what they do. Patrick Game says, you don't need to read this on air, but protect your voice. Hydrate like crazy. I am. I also have Entertainer's Secret. I love it. It's in my drawer. I used it before this. I did not protect my voice well in all of the ridiculousness I got up to, but I also had two live events on the same day. So 2 speaking engagements on the same day, plus karaoke. I knew I was in for it, but I love Entertainer's Secret. I have it in my drawer. Late But We Ride. Thank you. Thank you for the epic candy unboxing. Hope the boys love it. I'm so excited, and I am going to be sharing their response to it for sure. Thank you. It was epic. The candy unboxing was incredible. The candy's incredible. I'm so excited to share that with them. I just got home today, so we're going to have to do all of that, because it was a mess going to the P.O. box, grabbing everything that I needed for the event, and then I had other stuff in my P.O. box too from y'all, which is always blows me away with the generosity and the kindness and the thoughtfulness. It always just absolutely warms my heart. I love getting to share that with the boys too. So I had picked up all the stuff for Adam and Zach, who this weekend we were referring to the boys nonstop. It's like, did you talk to the boys yet? And then I had all the other P.O. box stuff, and I didn't want to be like, here, take this back. So the car was, I mean, you guys saw it on Instagram. It was just chocked full of all the things. It was a mess, but it was great. Did I forget to read that one? I thought I read that one. Darn it. Did I get on a tangent? I apologize if I did. I don't think I can get it back. I don't know where it went. I'm sorry. KJ filed a motion to dismiss, and then both attorneys agreed to file joint discovery schedule, which didn't include a motion to dismiss in the schedule. Does this matter? I would need to go back and look, but no, the motion to dismiss would have gone on calendar, and it's already calendared, would have gone on calendar. And if they wanted a stay of discovery, they would have asked for it. So no, I don't think it is tremendously significant because they scheduled a date for the motion to dismiss when they did the discovery thing. I just don't think they're going to get I don't think we don't have to turn it over discovery is going to be persuasive to the court. Expect Children's Hospital called by Johnny or Amber. I would need to go back through the witness list and see who has them on the witness list. I imagine Johnny will call them. That would be my guess. Question, how much protection is allegedly from slander and libelous actions? Not a ton, depending on what is said. You can't just make somebody up or make something up and just be like, allegedly, because the implication is still there. So it's very hard to give a broad answer because circumstances matter. The way things are said matter and the context matters. But it's not a blanket like, oh, it's alleged that. That's not a blanket protection. But saying the article in Vanity Fair alleges that the ex-business partner said this, that becomes more protective because you are accurately re-reporting a thing. So sadly, it depends. Can we do a sidebar and do a cheers? Sidebar. Cheers. Yes, we can. Lawnard cheers. Let's see. K-Rab said Amber Heard fought tooth and nail against allowing cameras in the courtroom. What is going to come out looks bad for her. I think, honestly, right now what we're seeing is it looks bad for both of them, and it's going to continue to look bad for both of them. But yes, I'm sure I would be worried. I'm sure they would be worried about I'm sure she would be worried about it. Stuff is going to absolutely come out. This is a fourth phase of malaise. That's a great handle. With that, it just depends. Public figures can be public figures, and there are case law defining public figures. You can be a public figure for all purposes, like Cardi B, for limited purposes. But then there's also whether the statements are regarding to a public thing, and this came up in Johnny Depp and Amber Heard too. Are the statements regarding a public thing or a private dispute? Like talking about Johnny Depp's divorce, even though they're public figures, might be a private matter, not a public matter, unless it's already been dragged into the public. So public figures are one thing, and then it depends with regard to context. And then there are also limited use public figures. And it's something that gets litigated quite a lot. Celebrities, pretty clearly public figures for most contexts. People who are broadly public on the internet for some purposes can be public figures. You can have limited purpose public figures if something is very newsworthy, happening with them. Politicians, very clearly public figures. So it really, really depends. Would somebody like Mr. Beast be a public figure for all purposes? I think there's an argument that not for all purposes, because they make video content. They are publicly known, but they don't share everything about their life. So maybe not every context is newsworthy, even though they might be a public figure. So it depends. Question, isn't the First Amendment just a restriction on the government? How does it tie into defamation at all? So the broad principles of free speech and not restricting speech play into what you're allowed to say. Defamation is a restriction on that, where you can actually sue someone for what they said. It's only in context of defamation you can sue someone for what they said. People can say all kinds of horrible, offensive shit, and you can't sue them for it because what they've said is horrible. But in the defamation context, you can, because it's not protected. And this is especially true when it comes to people who are broadcasting. You can't sue a radio host because they said something awful or offensive or whatever, but you can sue them if they say something that is defamatory. So hopefully that makes sense at the end of the night as we were getting into it. But the First Amendment, as it's a restriction on government, goes to what government can limit with regard to speech, but it also goes to what can be limited with regard to speech throughout the way that we speak and when speech is actionable in the context of a case. I've been spending the week with Legal Bites, but I'm so happy to end with you. Well, thank you. Thank you for doing this, even though you're tired. I love being with you guys on Friday Night Live. I love coming in and saying hi. We had big live event. It's been a very exciting week, but I love being here with you guys. And I know Legal Bites does a great job breaking stuff down. So I know I'm not going to be streaming top to bottom every day of this trial. I just absolutely don't have the capacity to do that with everything else going on. So I'm glad that she is, and I will be streaming when I can. Motion to name your new friend Lewis the Loctopus. Well, we will put Lewis the Loctopus. I might have to do a community poll to name the Octo, but Lewis the Loctopus is on the list. Absolutely. Try arnica cream for your throat magic stuff. I hear I have some arnica. I will. I have some arnica for all of the things. I love it. Lost in a Crowd. Thank you. We've gotten through all of the super chats. I know there's more questions, so I'm going to try to get. Oh, it's been 2.5 hours. We're going to try to get to a few more. Andrea, what do you think about the substance abuse allegations against Johnny Depp? I'm not surprised that they're bringing them up. They're going to keep bringing them up to try to make it excuse his behavior. I don't know how effective it'll be. It depends on the jury. But they are absolutely going to keep bringing it up. I mean, essentially, we've got credibility against credibility in this case. So that's where we're at. Question, where does the definition draw the line of journalist? Can you call yourself a journalist because you have a YouTube, blog, Instagram, consumed by an audience for the privilege of protection rights? It depends on how the individual state defines it. There was a case in Washington where a YouTuber was like, no, I'm media. And the court was like, no, you don't fall under the definition of media for the state of Washington. So it really can depend state by state how broadly they take a look at that, whether they mean journalist that follows journalistic ethics and actually reports for a media company that is a registered media company, how they define media company, or if it means somebody who publishes something. Because if it just means somebody who publishes something, all of us could be considered journalists. If we write things on Twitter, those are technically things that are published. So it very, very much depends on the location, the state, the law as it relates to the state. And I will need to look into Minnesota's a little bit more to kind of answer that question more on point. So it depends. Sorry, I hate that answer so much, but it really comes up so often. This is why lawyers get paid. Lawyers get paid to answer the it depends. Question, how many jury votes needed to win a civil case? For example, 5-7 needed. Then what if it's 4-7 for the plaintiff? You can get a hung jury. I need to look at Virginia's because off the top of my head, I can't tell you because I did not do civil trial. I know there's a number. I do not know it off the top of my head at this very moment. It is completely eluding me. But yes, you can have a hung jury in civil cases as well. So, question, why was the Todd Chrisley defamation case filed in Minnesota? Because that is where KJ and her company are based. So instead of having to file it somewhere else and fight over jurisdiction, they said, we're just going to file it here so we don't have to fight over it, which is always a strategy. Question, what do you think Johnny Depp will do if he wins this case? Can he sue criminally? No. So there are no charges to be brought against Amber that I can see at this point. Some of those statute of limitations have passed for those actions, but also to pursue criminal, you need to start with the police reporting process. But he can't just choose to do that now. I don't think he could choose to try to report it. It doesn't mean it'll get prosecuted. So no. What does he do if he wins the case? I think he tries to regain his career and his name and his reputation. I think that's what he does. I mean, I don't even want to make a joke and say he goes to Disneyland because it's just, what do you do? I mean, I don't know if this helps any of them. Everything's going to be out there now. I don't know if it helps any of them. You guys are like, yes to Loctopus. Let's see. Are Tati's lawsuits done and gone? No, they're still very much going. She has the lawsuit. I need to check in on what's going on. It's been a while. There's the lawsuit in Washington state and then the lawsuit in Nevada. So the business partner stuff is still ongoing. Question, where should I join? Is it better to be a member on the channel or Patreon? I don't think better. It depends on which benefits you like more. So on YouTube, there you get the badges and the icons when you're a member and you do the members only live stream and that's all broken down. And then on Patreon, you have access to the members only live streams. You don't have access to the badges here on YouTube, but you also have access to the I Have Thoughts podcast and some of those behind the scenes things that live just over there. So it just depends on your preference. Gosh, how many times have we said it depends tonight? Too many, but it's preference. So there are some people that just are like, I'm on YouTube. I want to do the badges on YouTube. We just do YouTube. I just want the members only live stream. And then Patreon has the tiers. So you can check them both out and decide which benefits you like better and which ones meet your needs. If you want to just stay on YouTube, that's perfectly okay. That's why we have both. Do lawyers judge potential jurors on their appearance? Sometimes. Yeah, absolutely. Sometimes. It depends. Like a juror who, when I start talking to them, sits there and is like this, is probably not the right juror for me. I guess that's more body language than appearance, but it's partly appearance. A juror who seems really distracted or like they have a lot going on in their life, that was always for me. I'm like, can they sit here and listen through this? Like they seem like they've got a lot going on. You can tell when people are in it. I would look at what people were reading. I would look at what people chose to wear to court. Like, do you care about being here? Are you wearing a shirt that says like, fuck the man? Because they're probably not going to want to listen to my police officer witnesses. So yes, it depends. I think body language matters more than just like appearance, if that makes sense. I guess presentation and body language mattered more to me. Can you elaborate on how First Amendment does not cover defamation? Defamation is a false statement that is reputationally damaging. And because of the damage that false statements can do, we don't duel anymore. You can't like shoot somebody for, well, I guess people do still, but I'm not going to say they don't, but people use a duel over their honor and their reputation. The damage to reputation, it's like the shit can't be put back in the horse. What is said can be damaging, and that damage can't be undone, which is why there's a civil action to try to redress the injury after. We have a very reactionary system. Like bad shit happens and then you can sue over it or you can be arrested over it, but it's like the shit has already happened and then you try to fix it. So the goal of the lawsuit is to try to use money to fix the damage. And more, I think the goal of a lawsuit now is to get the information in front of the public eye as much as it is to redress the wrong that happens. So, yep. Octo said, I picked up heavy things and put them down as a hobby. You do, and you pick up heavy things and put them into the car for me. It was very, very helpful. Thank you, Octo. Motion to name our new friend Lewis the Loctopus. Oh, is that I am behind on the chat? I'm sorry. Did you say they are making Legally Blonde 3 with Reese Witherspoon back as Elle? I saw it on IMDb. I'm so excited. I did see that that's happening. I am also very excited. Love your channel. I'm pretty new to it, but your take on things are amazing. From a foot soldier, LOL. Well, thank you, Cam. I'm glad you found us. Welcome. I try to bring, legal perspective and sometimes snark, because sometimes things just deserve some snark, but I try to talk you guys through the way I think about the things, because I don't expect the law nerds to all agree. Like, we're not here to all agree. We're here to have conversations. And so I'm not here to convince you guys one way or the other. I guess it's not for me to say I try not to make content that is persuasive. If I feel a certain way about a case, I will always tell you. You guys know how I feel about the H3 Kavanaugh case. I have feelings. I think it's a stupid lawsuit that Kavanaugh brought. I'm going to continue to tell you that. There is no like, this side says this side said this. I mean, it is, but it's also like, this side pisses me off. But I really try to present things so you can decide on how you think through things, because this is really more about the process of understanding and thinking through. So we are evaluating the things that are going on around us. And that really is the goal of my channel, not to do advocacy. I can do advocacy. I really try not to advocate for one side or the other. I try to present the sides and talk through them, give the legal context where I see it, give a little bit of how I see what's happening, and then let you guys decide for yourself as we look through these lawsuits, because it's for you to decide, not for me to tell you what to decide. And I think that's a much more powerful thing, how you feel about something. We don't all have to agree. I'm going to take one more question after this, and then I have got to go. My voice is, I am All of me is done. I am very tired. Question: what do you think of Amber's court fashion choices? I think it's bizarre. She's not trying to look more feminine and friendly. I don't know what their jury looks like. So I don't know the makeup of their jury. We do not see the jury, which is fine, but I always like evaluating a jury with my own eyeballs from my own experience. So I don't know what their goal is with it. But it is interesting that she is choosing some very kind of strong suits. It's very different than how she presented in the UK. I wonder if we will see a switch. This is what I'm looking for. I like how she's been doing her hair. I wonder if we will see a switch in how she presents when they get into her case in chief. I'm wondering if we will see a change throughout the 6 weeks, but I don't know what they decide. I don't know what and why they decided. Because their goal in this case is to present her as a victim and to present her as somebody who was horribly, abused and put down and unable to stand up for herself. And then we're hearing testimony in Johnny Depp's case, because his case goes first, about her being very aggressive and very I think the therapist said she was like a jackhammer when she spoke, like somebody who is very aggressive, someone who spits in somebody else's face, somebody who's very confrontational. And so you would think if that's the perception that's coming out from the plaintiff side, and they know that's what the plaintiffs are going to present, you'd want to counteract that almost with the way that she dresses. And she's not doing that. And it's very interesting to see. It's very interesting to see that. So I'm not sure if they will change it. So I don't know why the choice was made. I really don't. I don't love it, but I don't know why the choice was made. I would love to know why the choice is made. Um KCD said, how do you properly mention people without their whole name in the chat? That is not what I was trying to do. I don't know. That's a good question for the mods. Can you talk more about courtroom attire for lawyers, defendants, do's and don'ts? Yeah, all night, all night. You guys are asking great questions, but it really depends. It depends on the jury. It depends on the type of case. It depends on the lawyer. I mean, I had a lawyer in Long Beach, a defense attorney who dressed impeccably all the time. So well put together, like exquisite three-piece suits and ties and matching like pocket squares and the whole thing. Some jurors found him to be so charming and just adored him. And some jurors found him to present as a very slick defense attorney, and they felt like he was trying to dupe them. It wasn't a lot, but it was some. And those are the things you have to consider. If you're too slick, does a jury think you're trying to pull something over on them as a defense lawyer, particularly, and in criminal? If you're too slick, are you trying to pull something over on someone? But if you're too not slick, does a jury trust you as much? Like if you look disheveled, do they trust how you're presenting their case? And then from a prosecutor perspective, you don't want to look like the heavy-handed law. You don't want to present too formally, because it's like the weight of the government. So I mean, also I was always exhausted. So I always went for like, oh, good enough. These are my suits. This is what I've got. Sometimes a fun jacket. It was mostly black pants, black shirt of some kind, jacket, shoes. That was it. And I also didn't want to stand out. I wanted to make sure my case stood out. I always tried to give kind suggestions to help my witnesses and victims be more comfortable in court with what they wore, and always ask them to just wear appropriate attire for them that was respectful of the court setting. But it is something you have to be mindful of, knowing who your jury is as well. Jurors in some areas are going to be much less concerned with how people dress, but jurors in other areas might be like, wait, women lawyer wearing pants, what is that? I mean, God help us all. The jurors are still like, why are these women out here working and wearing pants? Why aren't they in skirts? But it happens that jurors expect female attorneys to be in skirts all the time. And we're seeing lots of skirts from Johnny Depp's female lawyers, because that's what some jurors expect as professionalism from the attorneys. So it is deeply considered. It should be considered. But you've got to come across as not too slick, because people don't like feeling fooled. But you also can't be too, hodgepodge. together. It's got to be appropriate for the location. And I think both Johnny Depp and Amber Heard are trying not to be Hollywood superstars on trial because that can be a little bit too much too for a jury in Virginia or anywhere. Ruth or RBG for the octopus name. I'm going to have to you guys, I will take a poll. I will take a poll for sure. Emily went for Emily went for a very muted, like, I have 5 players of black pants and black shirts and a variety of jackets. And that was it. Some days I was a little bit more fun. I did have a really cool pink jacket that I loved, but I didn't wear it for trial. I wore it for other court hearings. Is it possible that Eve Barlow was added to the witness list? I haven't seen a new witness list filed. Anything's possible, but I think she was barred for other reasons, but anything's possible. But I haven't seen that filed in court. If we see it, we will. Gustav for the octopus. We will have to do a poll. All right. With that, you all, have you guys been asking about my lips all night? I did a lip flip, which flips them up so they don't look so small because they are shrinking into my 40s. It is great. So Botox, it helps your upper lip flip, and then a little bit of filler on the edges. Yep, absolutely did. So that is why they look different. We have lots of live events coming up. We cannot look deflated. But with COVID, that is something that hadn't happened for quite a long time for me because I hadn't been going in because of COVID. So that is what it is. But the flip is the secret of the entire thing. So yeah, thank you. The flip is the thing. Everybody doesn't, I don't know. People don't think about the flip, but a little bit of Botox and it stops the muscles in your mouth from pulling your lip down. So it can just let them be flipped. Oh, the gloss is all Gerard Cosmetics, but the flip is the secret. So a little bit of Botox in the top of the lip lifts them up a little bit and then you get it. So now we're done. As my thing starts buffering. Yes, we did have celebrities get called for jury duty in my own court and in other courts. Yes, it did happen. Most of the time they did not stay. Sometimes they did, but not ever in any of my cases. I mostly had athletes come in because of where my court was located, not movie stars. But I did have somebody who did production for Jersey Shore, and it felt like they were a celebrity to me. I loved it. I loved it so much. So I never knew juries could be impaneled for civil defamation cases. Learn something new. Happy weekend. Yes. Oh, lots and lots and lots. Well, thank you guys. You guys don't consider lip stuff just because of me. Again, that is a very, very personal decision. It is a very, I will never disparage anybody for deciding to do stuff, even if I don't think it looks great. You've heard me talk about Jennifer Aydin's nose when I talk about the Housewives, because I thought she looked beautiful before, but sometimes there is a personal choice. And I didn't, again, my top lip was starting to disappear in photos and I just didn't love it. So I found somebody great here and was like, what can we do? And they're like, we can flip this. And I'm like, yes. So that is why they look slightly different. Not something I don't talk about, just something that, I don't want to encourage someone to do something because I did something. So I'm always very mindful about not being like, go do the things that I do, because I don't do a lot of things. That's it. That and clear skin. Motion for DEF CON nap. Yes. 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 It is time to say goodnight. Y'all are so tired, but I'm happy to ask the questions for you. So, and we got one more. You guys are trying to hold me in. Watch Legal Bites this week during the Johnny Depp trial and felt like I was cheating on your channel. No, I know how you feel. It's like going to a different hairdresser. There's plenty of room for all of the subbies, to all of the channels, to all of the YouTubers, the law tubers. Find the people that you like. I probably subscribe to like 300 YouTube channels plus. And a lot of them did similar things. We all have different takes and perspectives. We all have different ways of explaining things. We all have different insight that we bring. Listen to the people that resonate with you. Never cheating. There is so much room in this community for great commentary and insight. And Alita's been doing amazing work on this trial. So absolutely support her channel and help her channel grow. I can't wait to see her at 100,000. And I hope this trial grows her channel as she covers it. It takes a lot of dedication to do it. And it's fantastic. I love seeing it. So y'all, it's great to see you. And I will talk to you soon. Thank you for being here. Thank you for being a law nerd. Good night. So long, farewell. I'm going to go sleep. And oh gosh, we're getting up early tomorrow because we've got farmers market stuff before Easter. You guys have a good Passover. Have a happy Easter. Enjoy celebrating. And I will probably be off of social a bit while I'm spending time with my family. So I will see you back on Monday. I encourage you to give it a try. Just give a social day off a try. Just give it a try. Give a no social day a try. Let me know what you think of it. I find them to be quite helpful. And I will talk to you later. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.